Good afternoon, and welcome to the Appellate Division First Department. I'm going to begin with the call of the calendar, but as you all know, the usual drill. The panel is fully familiar with your briefs, the record, so please ask for only the time you actually need, not the time that you want. And please don't be disappointed if I cut down your time, because if the arguments require additional time and my colleagues want to ask more questions, I never interfere with that, okay? So don't get dismayed by the amount of time that you get. If you make a good argument, we'll keep it going, all right? That being said, there's 6 hours of requested argument time. I doubt any of you want to be here that long, and I know that your colleagues at the end of the calendar certainly do not. All right? People versus Fabian Green. Okay. 6, 2, and 6. Hayden versus Mandelsberg. Good afternoon. Okay. 5 and 1 and 5. Remember what I said. Nancy versus Juan B. Submitted. Mariette versus Amber Court. Okay. 5 and 1 and 5. Pacheco versus Trustees of Columbia. Okay. 5 and 2 and 5. People versus Francisco Colon. Submitted. Building 44 developers versus Pace Companies.
Appellant requests 7 and 4.
Okay.
Respondent moderated 4 minutes.
Okay.
Respondent premier elite 4 minutes.
Okay. So let's do 6 and 1, 4 and 4. Schoolfield versus Services for Underserved. 5 and 2, Okay. Okay. 4 and 1 for JC, 5 and 1, and 6 for the plaintiff. People versus Naquan is submitted. Gadula, 26 versus Lightstone Acquisitions.
Good afternoon, Your Honor. Appellant's request 7 and 2.
Okay. Okay, 6 and 2 and 6 and 2 for both of you. And again, if the questions can keep going, okay? Andis Petroleum versus Occidental Petroleum.
Good afternoon.
Good afternoon.
Appellant request 6 and 2.
Okay.
Respondent request
6 and 2 and 6. And thank you, gentlemen. People versus Mitchell Hernandez.
Good afternoon. Appellant request 7 and 2.
Okay. 6 and 1 and 6. Fowler versus Shipkovich.
Good afternoon, Your Honor. For appellant, 4 and 2.
All right. Is there a respondent? Okay, you seem to have scared them away. Would you like to submit?
Your Honor, if the panel has any questions, I'd love to have a couple of minutes.
Are you asking us? Because I can poll my bench here. Does anyone have any questions? I think we're good. You want to submit?
Yes.
Thank you so much.
Thank you, Your Honor.
People versus Christopher.
Counsel, have a seat.
Wait until the end of the call, okay? All right. People versus Christopher Malloy. Submitted. Williams versus Bronx Harbor Health is submitted. Ader versus Ader is submitted. That is the call of the calendar. Counsel, you may now leave, okay? All right, first case on the calendar, People versus Fabian Green. You may proceed.
Thank you. Good afternoon. Margaret Knight from the Office of the Appellate Defender on behalf of Mr. Green. From start to finish, this is a case of prosecutorial overreach. Even by the prosecution's own proof, this started out as a chance encounter of two people who nearly collided on the street, and during a subsequent argument, Mr. Green allegedly took the complainant's phone when she threatened to call the police.
Counsel, let's stop there before you continue, and let's talk about the argument and what happened on the street, directly as it relates to the perjury charges. Assuming that we were to agree with you that the charges were multiplicitous, specifically 2 and 3, because one was, he was acquitted, what would be the remedy?
We asked this court to dismiss both of the charges because the problem with multiplicitous charges is that it can lead the jury to believe, just by virtue of the number of charges alone, that the defendant must be guilty of something. It also creates the risk of a compromise verdict. So given the risk of spillover effects, we would ask the court to dismiss both charges.
But isn't that belied by the jury's acquittal on the first perjury charge? So I mean, that argument might work had he been convicted of all 3 perjury charges, but clearly the jury here discerned and separated the evidence such that they found the first perjury charge to not have been sustained. So how does that acquittal on that charge influence and impact your argument?
Well, the second risk that I just cited was that the jurors might compromise on a verdict. So the fact that they acquitted on one and convicted on another could show compromise just as much as this discernment. It also can reflect that the count 1 was much weaker, a perjury charge. I mean, there was a very serious question of materiality there.
I agree. Beyond that, it seemed to me that the video that was offered proved that there had been an argument, which was the basis for the first charge, correct?
Yes, there was
first
definitely an
perjury charge.
argument, yes.
Okay.
Does it matter that he was sentenced to concurrent time on the other 2 perjury charges? Doesn't that kind of alleviate any necessity for corrective action?
Absolutely not. I mean, part of the sentence that he received, I mean, we could address the sentence later, but part of the sentence that he received was premised on the fact that he was convicted of 2 separate counts of perjury. So if anything, that would, I mean, it would also argue for a sentence reduction in this case. But no, I mean, also just stepping back, we asked this court to...
What was the minimum sentence available on a perjury charge in this context?
Well, the minimum sentence was 2 to 4, but the court didn't have to sentence him consecutively. So the court gave, I think, we're asking...
Why would the court not have to sentence him consecutively insofar as the first charge, being the grand larceny charge, was a separate occurrence? It was the act complained of, and the perjury was just by virtue of the statements he made during his grand jury testimony. So why would that not be an appropriate situation where consecutive time is not only appropriate, but warranted?
Because this court should look at the aggregate sentence and the circumstances of this case. Mr. Green, although he had a prior record of low-level felonies, they were indicative of a history of trauma. He was orphaned by the time that he was 3. His mother died of AIDS. He was subjected to physical and sexual assault. He had been drinking on the night of the incident. He suffered from anxiety, depression, and PTSD. And he did not go out, even accepting the prosecution's case, did not go out intending to steal a phone this night. It was a heated and unfortunate verbal fight, as happens on the street of New York City, and when the complainant threatened to call the police, he made an impulsive decision to snatch the phone. There was no physical injury. It was returned soon thereafter. And of course, again, accepting the charges, should not have gone into the grand jury, but he has served 6 years now for what is, again, at most a phone snatching. And so that this court should look at the full range of circumstances and not just mechanically apply consecutive sentences merely because the court could, but look at everything that happened here and Mr. Green as a person to say that a maximum term of 8 years is simply excessive. And
Is he not eligible for parole at this point in light of the fact, you said he's in for 6 years. When we combine the two sentences, 4 to 8 would be, it would seem 4 would be the minimum he physically has to serve. Is there a reason that is present in the record why he has not been paroled?
There is no reason in the record why he hasn't been paroled. I can say outside the record that my office is working with him and stands ready to assist him, and that Mr. Green is motivated to get mental health and substance use treatment, and our client services team has been working with him, but he has not yet been released on parole.
And one last question, which citation would you refer to us that would enable us legally to make these sentences concurrent instead of consecutive?
I would direct the court to the penal law that the court was legally permitted to impose consecutive sentences. I'd have to look at which section of Article 7.
Concurrent.
Or sorry, the court was legally able to impose consecutive or concurrent sentences. I don't think respondent disagrees with that, and we're arguing that concurrent sentences are appropriate here.
Thank you. All right, counsel. You may proceed.
May it please the court, I'm Philip Tisney for the respondent. I'll start where the panel started. The 2 counts, even if the 2 perjury counts of which he was convicted, even if you think they were multiplicitous, and we don't think that they were, but even if you do, it's really sort of no harm, no foul, because he received concurrent sentences on those 2 charges, and the only remedy that New York law recognizes for a multiplicitous count is dismissal of the redundant count.
Well, what about the fact that your counsel argues that maybe it weighed into the way the court sentenced him on the grand larceny and just the completeness of that? Does that matter?
No, and I think as Judge Manginette picked up on, this was not a jury that was overwhelmed by overcharging, that it couldn't acquit this defendant, or that it was overwhelmed to convict him on all counts. Of course, it acquitted him of one of the perjury counts and convicted him of only the other 2. And so this was a jury that had its senses, was able to discern the evidence, and decided that that on these 2 perjury counts that the defendant was guilty.
Could you explain why this court should uphold the consecutive sentences for basically a phone snatch?
Well, consecutive
The victim
sentences,
wasn't hurt. She was never struck, although there was a threat to strike her. So she was never hurt. The phone was returned to her within hours of the event, if not less. And so I certainly am not undermining or lessening the severity of committing the crime of stealing somebody's phone. Please don't misunderstand me. But the question is, does that act warrant a 4 to 8 sentence?
no, it's not that act, Your Honor, because by imposing concurrent sentences, what you would be doing is saying that there is no punishment for going before the grand jury and lying.
So, but what we would be saying, to take your argument to its next logical conclusion, is that lying before the grand jury is the equivalent of the commission of a robbery, right? Because
I don't know how you would be saying that.
because he's being given 2 to 4 for the same, which is the same amount of time the court thought was appropriate for a robbery.
I mean, the legislature has prescribed sentences for defendants in this position. He's a second felony offender. The minimum sentence that he could receive on the perjury charges was 2 to 4, and that's what he got.
Right.
The swing on the larceny count is smaller. I think it's 1.5 to 3 on the minimum, and 3 to 7 or 2 to 4 on the maximum.
Right.
I don't quite remember, but he ended up getting 2 to 4, closer to the maximum there. I think the real question on the sentencing here is whether the two counts are to run consecutively, and here I think the trial judge got it precisely right. Like if it doesn't run consecutively, then it effectively serves as no deterrent for this defendant or any defendant to testify truthfully in the grand jury. And that's particularly important in cases like this where you see the defendant go before the grand jury and give a very detailed statement, which is almost entirely false, and then prompt the grand jury to come back and request additional information from the people before they're deciding to convict. They asked for information that was not reasonably tailored to come up with reasonable cause to indict. They're talking about the people disproving his claim that he was innocent. That is a standard that the people are not required to disprove at the grand jury, certainly, and it is not one that the legislature has directed that we disprove. So there was a reason that this defendant got consecutive sentences, and it's one that I think is important in this case and other cases as well. If the panel have questions, I'd like very briefly to address the cell site data
Please do.
the issue. An expert is required for cell site evidence only when he seeks to testify about the specific location of a phone based on technical information about how cell towers operate. That is the line that courts across the country have drawn. That is a line that this court has drawn more or less in Esquilin.
I think the benefit to the people in this case is that the defendant here failed to lodge a proper and full objection.
That's correct.
Okay, but there's no question that the testimony of, I forget the name of the individual from the DA's office, the tech, he was not qualified to give the testimony, nor was he introduced as an expert. So had a proper objection been lodged, backed up by a verbal explanation for it, I venture to guess that the court would have sustained that objection.
Well, again, we agree that the claim of error is unpreserved. We disagree. I mean, Igor Groisman, who was the witness, was not offered as an expert. He was not qualified as an expert.
Yes, but he testified about things of which are not the general knowledge of your average juror.
Well, I think his
I don't know whether what issues impact whether a cell tower picks up a particular ping. According to some of the evidence in the record, there's suggestions that it depends on how close you are to a tower, the strength of the tower, and there was no expert evidence about that.
No,
so,
the overwhelming balance of his testimony was that based on the cell tower's location, you could infer that the phone was in a general vicinity. That is the kind of testimony that this court...
Had he kept himself to that, I agree with you.
Well, and the court kept him there too, and it also gave narrowing instructions, and of course, the evidence was overwhelming, even if there was some portion of his testimony that was error. So what we'd ask this court to do is adhere to the line that it's drawn in its decisions, permit this type of some lay testimony on cell site data in some cases, and affirm the conviction here. Thank you.
Okay.
Addressing the cell site location information very briefly, yes, Mr. Green, a pro se litigant, made general objections to this, but we do ask the court to look at pages 222 to 227 of the record, because the court did ultimately make a ruling that Mr. Groisman was qualified to provide opinion testimony. In response to one of Mr. Green's objections, the court said, I need you to lay a foundation for that. And he said I'd had basically a one-day course on mapping software. So while, of course, Mr. Green could have made a more directed objection, the court did allow him at that point to introduce speculative, what he admitted was speculative testimony, but to talk about why the phone connected to different towers at different times. So the court actually allowed him to exceed the testimony, the testimony allowed in Ortiz. And, we also would note that we asked the court to step back and look at the cascade of errors that happened here. Mr. Green, the prosecution not only called their own employee to testify about cell site location information that he was not qualified to do.
What about the fact that there was no specific objection made? Is that problematic, that only a general objection was made here?
Under 47005, CPL 47005-2, if the court rules on it, then that is in response to a general objection. That's enough to preserve the issue. Mr. Green also objected specifically to the prosecutor calling her own boss to give an opinion that he thought that Mr. Green's testimony satisfied the materiality element of perjury. And the prosecution, engaged in a litany of misconduct, but related in summation, but especially related to the cell site location information. And I don't have the pages right before me right now. I thought I did. But both Mr. Groisman and the prosecutor did not limit their testimony to general locations. They said very specifically, it's in this neighborhood, the phone connects to, usually connects to the closest tower. It was nowhere near where Mr. Green said it was. The prosecutor twice in summation used that testimony to say that the cell site records disproved his testimony because we know precisely where the phone was at that time. And that was fatal to his case, his defense, which was that he had found the phone. So they used that testimony in a way that was improper, along with denigrating Mr. Green by saying that he wanted to punish that bitch by taking the phone, by saying that he was a manipulative con artist and a bully, by telling the jurors that Ms. Chu told the truth and that she had no motive to lie. So we really do ask this court, even in the face of the evidence, to look at the cascade of errors that affected every aspect of this case.
Thank you so much. Hayden versus Mandelsberg. You may proceed.
May it please the court, Gerard Ferrara for defendant appellant Mandelsberg from Scahill Law Group. Your Honors, defendant requests that this court partially reverse the lower court below. We, of course, take no objection to the lower court's finding that plaintiff's comparative negligence is still a factor here, but take complete objection to the fact that they found the defendant, as a matter of law, was liable.
What evidence was put forth to negate that negligence?
Essentially, the near identical evidence that was put forth in Membreno, which was cited in our brief, where
all he says is he looked both ways, he looked in his mirror, he looked on the side, he looked over his shoulder, and yet he was unable to see what the vehicle and traffic law requires that you see, that must be seen.
That is correct, Your Honor.
There is no explanation as to why he couldn't see this bicyclist coming down on the side of the road by his door at 12:30 p.m. in broad daylight. There's no explanation for that.
Well,
Our case law is replete with these type of scenarios where people simply say, I looked back and forth, I looked in the mirror, I looked to the side, but I didn't see him. But yet there was no obstruction to prevent him from seeing him. What is the explanation for why he could not see what could have readily been seen?
No one is disputing those arguments, Your Honor, and you certainly bring valid points to the table. The issue here, and again—
Thank you. I don't get that often, so I thank you for that.
Well, the argument, again, even citing to Membreno, that near identical fact pattern was raised in Membreno, where a jury found defendant was not liable. They found him negligent And no one's disputing here that perhaps the defendant did certainly have a duty to see what was there to be seen, and perhaps if this court wants to infer negligence in that he did not see the plaintiff, that may very well be the case. But to assign liability,
Except that we have, in these exact circumstances, on hundreds of summary judgment motions, granted them. So it's great that somehow a case that slipped by the summary judgment court made its way to the jury, but that doesn't change our law.
well, it does in a sense that it wasn't merely a jury. It was brought to the appellate division who
But that was
affirmed
the
jury's
second
findings.
department? That was the second department.
Correct, it
right?
was,
That's-
Your Honor, and granted, that's not binding on this court, but it is certainly persuasive. The argument...
What does our department say on that issue?
Well,
I think it's more in line with what,
yes, and
My
Your
colleague
Honors,
is
I'm
saying.
not, Your Honors, I'm not disputing that. I'm not here to dispute the law. The issue here is much more of a fact-sensitive argument. And as...
So counsel,
let's
let's
talk
just, yeah, let me, I'm sorry, did you want to go? Go ahead.
Yeah, let's talk about the facts that are alleged in the record. So you have a car that's pulled over to the right, it's parked.
Yes, Your Honor.
And it's stationary for 2 minutes.
Yes.
According to the defendant, and he's there with his wife. And he says, I looked in both directions, but I saw nothing. I looked back and forth, I saw nothing, as my colleagues have mentioned. There is not an iota of evidence in the record that the cyclist did anything wrong in any way whatsoever. The claim that he should have been wearing a reflective vest, I don't know if you cycle, but anybody who cycles knows that a reflective vest doesn't help you very much in the daytime, and it was 12:30. All the cyclist was doing was going straight, and he indicated that he had his lights on and so on and so forth. So I don't understand, frankly, why, I'll be very blunt, I don't understand why this is being appealed.
Well, the argument, and again, this is a fact-sensitive argument. This is not a scenario where the car is parked on the side of the road and there is a generic area in the road.
The road being Montauk Highway in
Correct.
Amagansett,
Correct,
which
which-
has no bike lanes on either side of the road.
We've conceded that. That's not the argument here. The argument here is that there is a delineated white line parking spaces on that side of the road.
So counsel, what is the non-negligent explanation? What possible non-negligent explanation could there be for someone opening their door at the same time hitting a bicyclist? What could you, so let's assume that the plaintiff has made out its prima facie. I was driving along, the bike hit me, as it opened the door and hit me. So you're saying, I'm asking you, how could it be non-negligent if you looked and didn't see someone who was literally a second away? What could be the non-negligent explanation for that?
Even conceding that point, Your Honor.
No, that's it. That's the point. That's the liability. It doesn't
No,
have to be
no,
the
you-
sole
I-
proximate cause.
I-
It has to be a proximate cause. And once you find the violation of the VTL, because you didn't see and there's no non-negligent explanation for it, then the plaintiff has made out their prima facie on it is a proximate cause. Then, what our law says, and we all agree that you get to do at trial, is say he's also responsible. But that doesn't stop us from granting summary judgment to the plaintiff, does it?
Yes. And if you'd allow me to explain, I would argue
Sure.
it in this fashion. As I said, this is not where it's an unlined street. There is a delineated white line marking off a parking shoulder and a travel lane. It is the defendant's contention, which has not been disputed. Plaintiff can offer no evidence to dispute this. This is a matter essentially of the lower court making a clear credibility determination. There is a white line with enough room for the defendant to open his vehicle, as he has conceded the entire time, for the 2 to 3 inches that he has opened that door.
2 to 3 inches?
Correct, Your Honor.
How, counsel, what car door is only 2 to 3 inches?
You're saying this much, that the plaintiff hit the car with this much. This is 2 inches. That's what you're saying?
Your Honor.
You'll have time on rebuttal. You are way over your time, and you can follow this up on rebuttal. You're up next.
Good afternoon. May it please the court. My name is Jay Humans. I represent the respondent. I was just about to waive any argument, and I'll restrict it to 1 or 2 sentences. There's no evidence in this case, and it wouldn't make any difference anyway because of Rodriguez versus City of New York, that the plaintiff respondent was doing anything other than driving straight in his lane. The only thing that the defendant says is, I opened my door 3 inches, and therefore then speculates that the plaintiff would have been in the parking lane. If so, he would have hit the rear of the vehicle. That's it. Thank you.
Thank you. Okay, you have 1 minute.
As to the point I was trying to make, Your Honors, as noted, there is essentially 6 to 8 inches of space between the vehicle and the white line. Plaintiff cannot offer any evidence to dispute. And again, this is a pre-discovery motion for summary judgment. If the defendant's door is open and that door does not cross or even touch the white line, then plaintiff is in a parking lane as he's...
What case says anything about the door opening, if it doesn't pass the white line of the parking, it's okay for you not to look and see what's coming at you? What case says that?
Your Honor, no one's disputing negligence. I will concede the point of negligence.
Counsel, then I don't understand why we're here, as my colleague said.
If the door does not get into the travel lane, Your Honor, then plaintiff is the sole proximate cause in veering into the parking lane. That is the whole argument here. And again, this is a...
What evidence is there that he veered into the parking lane?
That's, Your Honors, as the non-movement, I'm entitled to the most favorable interpretation of the evidence.
Okay, thank you. Your time is up. I appreciate your argument. We have it, and we are familiar with your record and the briefs.
Thank you, Your
so
Honors.
much.
Happy New Year.
Same to you. Same to you. Mariette versus Amber Court. You may proceed, sir.
Good afternoon, Your Honor. My name is Domingo Gallardo, and I represent, just to be clear, I represent Amber.
Let me just say for the record, because I don't want to be accused of doing anything wrong, I know this gentleman. He graduated from my law school. It's a pleasure to see you here, and that has zero impact on how I will rule, so you know.
It's a pleasure as well, Your
Continue,
Honor.
Mr. Gallardo.
Thank you, Your Honor. So I represent Amber Court of Pelham Garden, LICSA, which stands for Licensed Home Care Service Agency, LLC, the movement in the original motion. There are 2 aspects to this case, obviously the denial of my motion, our motion, and then the granting of plaintiff's motion, which substitutes in Judith Lynn Home for Adults, LLC, doing business as Amber Court, Pelham Pelham Gardens. First and foremost, Your Honor, I want to say that the court's decision denying our motion, my motion, under 305C is incorrect and inconsistent in that the court clearly determined that more than 18 months had, this LLC had been created 18 months after the accident happened. So that should have been a dismissal. The case is going forward, and we're still in the case. So they need to be dismissed out. Moving to the second argument, which is with respect to Judith Lynn, that home, the actual home that ran the assisted living facility, it was incorrect for the court to allow for that entity to be substituted under 305C simply because they were never served. There is absolutely nothing in the record that they were served. The court relied on Ober. The court, my counsel relies on Medina, which is a First Department case. In both those cases, the court was very clear that the party had been served. Here...
Did you raise a service defense?
In below?
No, I'm asking you, as you're saying that it shouldn't have, because you weren't properly served, correct?
Correct.
Did you raise that as a
Well,
defense?
no, Your Honor, because it's not.
So what happens when you don't raise an improper service defense?
We have never answered on behalf, they have
What
never answered.
happens if you
I-
don't raise that defense?
Your Honor, if I may correct what I said, I did raise the service defense on behalf of Amber Court.
There you go. You raised it in your answer, right?
did.
Then did you move on it in 60 days?
No, Your Honor, I didn't
So
move.
there it goes. Isn't it under, don't you agree that under the CPLR, if you don't waive something, if you don't raise, because you can see the problem here, right, is that this is a ministerial thing, and it shouldn't create 3 or 4 motions. And so the requirement is, if you think you weren't served properly, you have to bring it up really quickly, and then we can fix it. But if you don't move, then you waive it.
Honor,
That's what the CPLR says, right?
The problem, Your Honor, with that argument, if I may, Your Honor, is that the Judith Lynn entity has never been served. So there's no service defense to raise on their behalf. How can I raise a service behalf on the Lynn agency when they've never been served? They've never received anything. Plaintiffs doesn't attach, there's nothing in the record that shows they were served. Not only that, the argument in the plaintiff's brief is that they served them because they served the facility with an affidavit that's not in the record. But if you look at the affidavit in the court documents, it's the wrong address.
Again, if that was your point, you had to raise it 60 days after you filed the answer, right?
But I never filed an answer on behalf of the Lynn. It's circular because I never filed an answer on behalf of Judith Lynn. Judith Lynn has never been appeared because Judith Lynn has never been served because all the court below did say was, we're just substituting it. And that's why service is important. Judith Lynn has never been served.
Judith Lynn is at 1800 Waring Avenue?
Yes, but they weren't served there. There was no service at 1800 Service Avenue. The record contains no affidavit of service at 1800
Waring.
Avenue. And if you look at...
Wasn't Judith Lynn doing business as Amber Court of Pelham Garden?
That's correct. It was
So it's a DBA. There's no dispute that the nursing home, Amber, was properly served at the place. It's a question of whether they can simply make a ministerial motion to change the name of an entity everyone knows is in the loop here.
That's not the facts, Judge. The facts
And at the end of the day, that fact means that the relevant parties were on notice of the claim.
But, Your Honor, that's not a fact. The fact is that there's no affidavit of service in the record, and if the court were to go and look for an affidavit of service that's filed below, the affidavit is for 104. It's 17 blocks away. It's in our briefs.
Okay.
We point out that the affidavit of service says that service occurred 17 blocks from...
Wasn't there another document, though, that actually
Yes.
reports the actual address?
Well,
So that, again, as my colleague, as my colleague noted, as my colleague noted, is just a ministerial.
No, Your Honor, that document which plaintiff relies on is the affidavit of electronic filing. Nothing
Counsel,
any
let me ask
party
you
ever received.
a
Nothing
different
that any party ever
question,
received.
and this is very brief. As to the affidavit of service, and you're saying that it's not in the record, wasn't this raised for the first time in the appellate reply brief?
As to the affidavit of service,
That the fact that you're saying it's not in the record, didn't you raise that for the first time in the reply brief?
but it's only...
Is the answer yes?
The answer is yes. The answer is the affidavit.
You can give us the rest of your arguments and your reply,
Thank you,
okay?
Your Honor.
All right. You may proceed, counsel.
And let me just ask you straight off, how do you respond to the argument that no one was ever served here with anything that would give them any notice of anything?
Right. There's actually multiple responses to that. It's true that the affidavit of service from the process server is not in the record. It's document number 2 in the NICEF document, which I did cite in my brief. There were some missteps here along the way, and I must say, including one by myself, in not noting that 104 Waring versus 1800 Waring in reading that affidavit of service. But there's 2 affidavits of service. One is, it says it was actually delivered to a Waring Avenue address to someone authorized to accept service. And then there's a second one at the, I think it's the registered place of business of the LHCA defendant, which is actually, was initially actually named in the case. To step back, to use that phrase for just a second, when you look at this and you get a complaint, and these people, by the way, have the same CFO, it's family-run companies, they're obviously related. When somebody at either of those two addresses gets that summons and complaint, and it says, this Amber Court Gardens assisted living or nursing home at this address, and it's a resident there, and he was injured on this date. It doesn't seem to me that there's any way that you can be confused about the fact that, that you're not fairly put on notice that the intended entity is the owner-operator of the assisted living facility, which turns out to be the Judith Lynn. And I can't say for sure that that was by design, but all along the way, that was never brought out by the defendants. The plaintiff, again, there was a misstep initially, and then they managed to discover that in the course of this motion briefing. But I would also point out, as far as it's the 3211E issue about the 60 days, I mean, under 305C, what you have is, yes, I accidentally named the wrong person. I put LHCA after it, and it should have just been DBA with the other entity. What they did was in the, sorry, I just lost my note. When they made the motion to dismiss, it was long after they had answered. So they had, you know, there was the complaint, there was the two services, there was an answer, and then it's
Did you
like 4
file
months.
those affidavits of service at the time that the service was made?
Yeah, it's
So they were in NICE, anybody could have seen them,
it's
correct?
document number 2.
Let me switch over and ask you, you're not disputing that the Amber Court LLC should have been dismissed?
No,
from the case,
that I,
right?
not disputing that. No, I think that, again, you know, the whole point of 305C is to ascertain that they've been put fairly, someone's been fairly put on notice and that there's no prejudice. This court has said that many times. And also, the issue with respect to service is, and there's also case law from the Court of Appeals and from this court, it's not whether there's like a typographical error or it's something in the affidavit of service, it's what really happened, were they really served. Had they raised that issue timely and had a traverse hearing or anything like that, if there was a genuine issue there, then it could have been resolved. But as the movement, they never showed that, they never disputed the service, they never showed that they hadn't been served, that
Is the name Amber Court of Pelham Gardens on the door or the place, right? So if
it
somebody
sure is.
walked in, they would think, gee, that's what it's called, right?
There are
And
affidavits,
then
yeah.
in response to the motion to dismiss, you didn't dismiss me, you cross-moved to fix it.
Yes.
Okay.
Yes, there are affidavits in the record about the family members who went there, what it says, what the website says. For some reason, the name Judith Lynn, that LLC, which actually runs it, they don't seem to like to put their name anywhere. But if you go there, you see it's called Amber Court of Pelham Gardens, and it's DBA. So unless there are any further questions, thank you very much.
Thank you. Okay.
You know, if I may, Your Honor, it's unfair to say they don't like to put their names anywhere. Plaintiff, in their submission, submits documents that after we made the motion, they did a thorough job, the job that any attorney should do. And they found, if you look at page 83, New York State Department of Health clearly lists the owner of this facility as Judith Lynn. They knew it was Judith Lynn. They could have sued Judith Lynn. They didn't sue Judith Lynn. As far as the timing of our motion, we made our motion immediately.
Sue her individually, personally?
Well, sue Judith Lynn, the corporation, the right corporation, because clearly, Your Honor, the right corporation to sue. We can all agree here, for the purposes of this, is Judith Lynn is the right corporation. Judith Lynn Adult Nursing Home LLC.
Doing business as Amber Pelham Gardens.
Correct. And
isn't that what they moved to do, to correct the service for
Correct.
that?
Correct.
So what
But
is the issue here?
after the statute of limitations had,
Also, I don't see the-
without having,
Right. I don't see the
without having
prejudice.
served them, Your Honor, I just stand by the arguments, and I respect the court's decisions. Thank you very much for hearing my arguments.
Thank you so much. Pacheco versus Trustees of Columbia. You may proceed. Yeah, bring that down.
Always. Good afternoon, Your Honors. Cheryl Corbin for the defendant appellants in this matter. Plaintiff was not entitled to summary judgment premised on a violation of Labor Law 241.
Counsel, I just wanted to know, how do you, I guess, address your arguments in light of this court's 2016 decision in the Landy case, where the facts were similar?
There's a huge distinction between this case and the Landy case. The Landy case involved an individual that was on an aerial workplace. So there was an articulating lift where the individual was suspended in a basket 10 to 11 feet in the air. And I think that's a clear distinguishing factor and what changes the two cases. And so that I do not believe that Landy.
Except I was on that case, and
Okay.
he was on a moving vehicle, just like this case.
Yes, but he was on.
So in terms of that, it is very similar. So I don't understand why the holding there would not apply here.
I think the distinction is that the aerial lift and the articulating lift has been held to be a safety device of the kind that the provisions of 241 apply to.
Well, the
whereas
buggy here was likewise being used as a safety device.
It was not used.
Particularly the break-in system that failed in the buggy device. That's the safety mechanism to prevent it from rolling on what it was a sloped surface.
I agree that this was a sloped surface. This was a ramp that simply somebody would drive upon.
So,
It's
counsel,
not-
let's talk about the sloping surface that you say was not, what is it, of a sufficient incline in order to qualify for Labor Law 241 protection?
Yes, it was simply a passageway as opposed to a ramp that was being used to
I'm
move
looking at the
items.
photograph, found in the record at 346, Exhibit F, and it shows the ramp, it shows an incline, it also shows a person walking up the ramp in such a manner that his body is actually arced forward, kind of like what a skier would do when they're skiing. I don't get it. The visuals alone of the photographs that are part of the record belie your argument.
I understand that this was a sloped ramp, but there was an individual that was simply riding on a buggy. This was not a height differential.
But the slope in the ramp would cause either an acceleration or deceleration in speed, right? And then, again, the safety device of the brakes, which is supposed to prevent from any, I guess, extra movement when something's supposed to be stationary, failed. That's what we have here.
We have here that the brakes failed, but this is not the kind of, that's just a simple, the type of accident that occurs on a construction site. This is not the type of.
Since when? Since when do failed brakes constitute the norm at a construction site?
It didn't say it was the norm and that it should occur. I said it's the type of incident that does not bring on the protections of 241.
And what case do you cite that stands for that proposition?
I think the cases that Nicometti, Melber, where there are problems that, for example, the conduit that somebody tripped over, a tripping hazard.
A tripping hazard is not the same as a vehicle you're in that's carrying, that is being used to carry loads of debris, right? Which is what this was, correct?
Yes, Your Honor. There's no indication here that the problems were caused by the weight of the debris.
No,
or the
what it
failure to
was caused
secure.
by was debris in the roadway, and which caused the buggy to not react properly, and his attempt then to stop the buggy failed because the brakes failed.
I agree.
So that buggy, and let's talk about the buggy, because there's no evidence in the record that what is required to be done with that buggy, i.e., check that the brakes are operational before you use them, was not done. We have written proof that that was not done.
I agree, Your Honor, that the inspection reports do not have a check mark next to.
So
that.
how do you get past that?
Well, we get past it because we believe in the first instance that this is not the kind of risk that is associated with the Labor Law 241. And then when we move on to the industrial code provisions, 9.2 requires actual notice. And if we look at the plaintiff's testimony here, there's no indication that there were any prior complaints with the.
How would you, in terms of 2.2a, how would you define the words "upon discovery"?
Actual notice, as the Court of Appeals has held in Mazzecchi.
Would it not be actual notice because you actually fulfilled your obligation to do the check of the brakes prior to putting a human being behind the wheel of that and risking their lives?
Your Honor, I think,
Wouldn't that be the required check?
I don't know why that was not checked, but I think we can also
Well,
not
counsel,
ignore the,
so I'm looking at,
I want to,
oh, I'm sorry.
yes.
please.
I don't think we can ignore the fact that we all know that the braking mechanism failed because of the debris that was run over.
We don't know that. There's no evidence in the record about why the brake failed.
The plaintiff had utilized,
Typically, a branch underneath wheels does not, in and of itself, prevent brakes from working,
well,
unless it was a tree.
the wheel is attached to the throttle. It's not a regular just automobile where
What evidence in the record do we have of what you're talking
Well,
about?
that's exactly how what the plaintiff testified to.
So counsel, we agree that, do you agree that there can be more than one proximate cause for a workplace accident? That's what
Yes, Your Honor.
Wisovich says, and that's what Pardo says,
Yes,
right?
of course.
Okay, so you have a ramp, you have a piece of wood that's somehow, a piece of debris in the wood on the ramp, but you also have failed brakes and an inspection form that is supposed to be filled out every day. It's called Power Buggy Daily Inspection Form, and it's the only part that's not checked out of 12 items is the brake.
Understood.
Only one. So why is that noticed, not noticed? That's the whole week where the accident occurred.
We don't know what that is, and it would
don't you
be
have
just
a
an
problem
inference. But the plaintiff is the one that obtained summary judgment here, and we think there were enough issues that were raised based upon just the way the plaintiff testified, and we believe that even that the slope of the ramp is not a sufficient elevated work site, so that the protection should not be afforded here. We agree that perhaps...
You'll have time on rebuttal.
Thank you, Your Honor.
Okay. And thank you. You dealt with this hot bench very well.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent in this matter. Obviously, we believe the trial court got this one exactly right, and we believe that the Landy decision is dispositive, as is the Lynn decision. I do want to point out something that I know you know. I'm going to try to truncate my argument, but this is even a little bit better for me than even you have been articulating in your questions, because my guy went flying. It's not that he felt he was injured in an elevation-related area. They said he flew, flying, went over. His coworker, you have the statement in 545 of the record, confirms every single thing he's saying. So if you look at this and you look at Runner, where you have an injury caused by an elevation-related problem, it doesn't matter how it starts, it matters how you're injured, that falls within 240-1, and that's what the trial court found, and that's correct.
Your adversary argues that the slope is insufficient to establish an elevated risk under 240. Why is she wrong?
She's wrong because the Lynn case says she's wrong factually and legally. If you look at the Lynn case, yes, they were using an articulation device, but they were going down into a basement garage. And by the way, as you know, this isn't disputed, it's a 3-level drop, SC1, SC2, SC3. On top of it, we have a brake failure case that's made out by their records. As Judge Gonzalez pointed out, there's, 12 different repair things. Everything's checked off but the brakes. So that establishes prima facie violation not only of 240, but 241-6 based on the industrial code regulations. One more point. Some of the
Was there an expert affidavit submitted by either side to support defendant's argument that the debris is what caused the brake failure?
No, it's not there, and it wouldn't make sense. And I do want to point out one other thing. One of the things I was nervous about when I came to argue on the brake argument, because Ms. Corman is a terrific lawyer, I've known her for a lot of years, she wrote a great brief. It's not a car. Just let me point that out to you, because it's important. The way that this device, this power buggy operates, as you know, is mostly through the levers. That's how it rolls to a stop, He's going down these different, ramps, and he's got a flagger with him, so he's not going at 5 miles an hour. They're walking down slowly. So the fact that the brake never failed before is irrelevant, because more likely than not on this record, he was using the levers and not the brake at all. And he did say, I depressed the brake, and not only did the brake not work, Your Honors, the force was so great, the gravity was so great, that the actual instrumentality that he was riding on went over on its side.
Counsel, I'd like to ask you a question with respect to 241.6, which you referenced.
Yes.
I'd like you to explain how it's applicable to the extent that C2I references level surfaces, and the ramp admittedly was not level. And then with respect to C2 double I, it applies when there's a 25% grade, but we don't have any indication of what the grade is.
So I have an answer for that.
So are you conceding that 241.6 does not apply?
I am not. Now let me give you my answer. My answer is, if you look at Ms. Corman's brief, one of the primary claims that they are making is that this was not actually an elevation-related differential because it was too low. I read C2 as saying that the brakes have to be able to hold the object, the instrumentality, the power buggy, at 25 degrees, not more, less. So her claim is that, when you read the brief, is that it had to be under 25 degrees. You can just do an angle on 25 degrees. If the 240 argument is it wasn't angled enough, then the C2 argument has to be the other way. You can't take both ends against the middle.
So the architect's diagram doesn't have any indication of grade, just to point that out to you.
That's correct. It's on 544 of the record.
Yes, I have
Correct.
a copy.
But my argument is that the photo, especially the photo that you referenced before, 346, 347, and 348, shows a grade that's certainly 25 degrees or less, and it's supposed to stop.
But we don't know that definitively.
We don't know that definitively in terms of an expert, but photographic evidence is no different than other evidence, and where a defendant makes a claim that is inconsistent with a regulation or a statute, I think the court can look at that and, on the entirety of the record, even without an actual measurement, conclude that the regulation was violated. I'm sorry, I won't go over my time. Thanks.
Thank you. You have 2 minutes on rebuttal.
As to the slope of the grade, I agree, Your Honor, that there is no evidence that it reaches the 25% and that it's purely speculative to believe that it did. And also, I just want to note that the fact that we're precluded from offering any evidence of the breaks due to the spoliation issue doesn't alter the fact that the plaintiff still has to make his prima facie burden of demonstrating the applicability of the provision in the first place, which we don't believe he has done to justify the award of summary judgment in connection with this. Going back to the whether or not this is an elevated work site and whether or not this was a safety device, we haven't found any case that indicates that a power buggy of this nature is the kind of safety device that has been determined to be a safety device of the kind that the Labor Law 241 protections go to.
The brakes on the buggy, the safety device that you're supposed to be able to rely, the worker's supposed to be able to rely upon
100%.
to keep him safe. So if the brakes go, that's the safety device. They go. He's on an elevation. So it seems to me like that fits pretty neatly and straightforwardly into 241.
I think the clear disagreement that I have, Your Honor, and respectfully, is that I view this as more of a motion issue as opposed to a height differential. And it was the motion of the buggy that caused the issue as opposed to the slope. And I think this is more akin to the cases where...
Okay, but so what? It's a proximate cause. Well, this is like the 4th time I've said this today. It's a proximate cause. It doesn't have to be the proximate cause, right?
We're not arguing that the defendants are entitled to summary judgment on any negligence claim. We're not saying this was a perfect work site. We're just saying that the plaintiff wasn't entitled to summary judgment based on the elevation.
But again, so if it's a differential-related accident, which here it is, on a ramp, the brake, which is the safety device, fails, and the plaintiff gets hurt. 1, 2, 3, that's the plaintiff's prima facie. What have you, so then That's it. There's nothing more to say about it.
Understood. The disagreement that I have is whether or not should be considered an elevation mark site.
Okay.
Okay.
Thank you very much.
Thank you so much. Okay. Building 44 developers versus Pace companies.
Okay,
You may proceed. You have 6 minutes.
thank you. Good afternoon, Your Honors. Our client, the appellant, is Pace Companies New York, LLC. They're a contractor. They've been sued by the developer for whom they worked for over $20 million. Our subcontractors, the respondents who worked on ductwork, who worked on maintaining temperature controls, have been dismissed from this case. We say that's error. They've been dismissed because we mistakenly, admittedly mistakenly, used a form in a purchase order that said Pace Mechanical Corp., which is a non-registered entity. However, throughout the course of this transaction, over 3 years, we paid the subcontractors with checks from the Pace companies, a duly registered entity.
So basically, the first purchase order document that was entered into between the parties had the Pace, the DBA name, right?
Correct, unregistered, and we can't cure it, which is why we're here.
Precisely. But with regard to that cure, I want to kind of dispense with that issue up front. That's 19 New York City Rules and Regulations 156.4. Am I right that while subsection C says that an assumed name shall not contain no indicator or organizational form, that there is no consequence, no remedy, no result that is laid out in this statute if that was the case?
Correct, the statute itself.
So that we then have to go to case law.
Correct.
In terms of the interpretation. And would you agree with me that Unique Laundry dealt with this issue spot on?
It did, because that was the only case we know of where, in that case, they sued under the name Unique Laundry Corp. It had the designator, as we have here. You're not allowed to then register that because of the designation. And the court said, doesn't matter. Absent intent to deceive, you could proceed. And
in fact, the quote was the certificate to change it, right? To add the doing business as certificate, that the certificate is not jurisdictional and may be amended prior to entry of any judgment.
Correct, and it's
Is there a judgment here?
No, we're in early stages.
Right, which means that we certainly fit within the ambit of this decision.
Correct, and the other case, which the lower court relied on, also fits with the general intent of the New York statutory scheme. If you're trying to deceive or defraud or confuse, you may be punished.
Is there any allegation by the other side that that is what was happening here, that you were attempting to deceive them?
I know there's no allegation of fraud. I don't believe there's an allegation of deceit. To the extent that they are going to claim confusion or something like that, again, I'll point to the factual pattern. Not only did they cash every check.
There was no confusion then?
No.
When they got the checks with the name, the Pace companies, correct?
And they applied for payment to the Pace companies.
So again, no confusion. They knew exactly who they were dealing with.
Yes, and worse or better or equivalent, there are change orders here.
Right, which had Pace Companies, correct?
It had, first of all, they applied to the change orders to the correct name, asking for more money.
And there was even reference to Pace Companies in the original purchase order.
That's actually true. On the purchase order itself, it's not prominent. I wouldn't rely on that totally.
There's a consistent thread through the entire paper trail here.
Yes, they definitely knew who they were dealing with.
Counsel,
to
could
the
you
extent
address-
that a change order
Counsel?
literally changes the dollar amount and changes the name of the buyer to the proper entity. Sorry.
With respect to Ringer Jeans, would you analyze the holding in that case? Does it indicate anywhere that automatic dismissal is required when an unregistered assumed name is used?
Great question. No, Your Honor. Ringer Jeans has basically 3 sentences. The first sentence dealing with this says, ordinarily absent an intent to deceive, a plaintiff may be granted leave until entry of a judgment to cure the statutory violation. So Ringer Jeans starts with the same premise as everything else. What happened in Ringer Jeans, if you look at the briefs and the records, there was a lady, Sarah Hong Roberts, who pretended to be Chappaqua Design and Sales. An individual was known to the people she was dealing with, marketing, sending bills to, and she cashed checks payable to a non-existent corporation who she pretended to be by endorsing them herself, probably a crime. So the 2 cases are not inconsistent. They both deal with the same exact...
Although, counsel, you'll agree that the statute itself says you can't commence an action under a DBA that's unregistered, right?
Correct.
And
Can
so
I
you're-
add one little caveat to that?
Sure.
It does. I agree with you. I wouldn't argue that. It's why you need the case law. It's why we need your honors. It's why we need wisdom. It's why we need common sense. But I would add that when you read both, Section 1 and Section 9 of the General Business Law, they talk about contracts and they also talk about the transaction.
No doubt. I'm just saying that there is an interpretation of the statute which says, 1, you can't commence an action under an assumed name, which you've done, under assumed name that is unregistered, and 9, which says...
No, the assumed name is, we've commenced the action under a properly registered name.
Under an unregistered assumed name, you are not permitted to commence an action, correct? And you did that. You commenced an action with documents that had an assumed name that wasn't registered.
We didn't commence the action under the unregistered name. We commenced the action under the name that was registered. We signed the purchase order in the unregistered
Well, okay, but then
name.
you couldn't sue because the documents that you're suing on aren't that name. But I mean, I agree with you. The whole point of the statute is to avoid fraud, right?
And deception and confusion, and there's none of that here.
Right, and there's no allegation of that here.
Can't be. Not a credible one.
Right, okay.
Okay.
Thank you, Your Honor.
Thank you. You'll have time on rebuttal. Okay. You may proceed.
Good afternoon, Your Honors. Glenn Kaminsky with Amity Demers McManus, counsel for Automated Logic Corp. And we would ask this court to affirm the decision of Judge Maisley for the very reasons set forth in that decision and order. This court,
What was the confusion? Since there were multiple requests for payment to the very company that you are now arguing should not be paid.
well, what I'm actually saying is that the statute's been violated. It cannot be cured in Roberts versus
What in the, like I said earlier, and forgive me for interrupting you, I will allow you to get your argument out, I promise.
You always
I thank you for that, because I try. Section 156.4 does not prescribe what the punishment is if you can't, for lack of a better word, right? What is the result if you cannot amend or certify your DBA?
Well,
There's nothing in that statute. Am I right about that?
There's nothing, there doesn't say there's a remedy there, absolutely.
Okay.
So we should read it as meaningless then, right?
No, I'm not saying that. I'm just saying that that the drastic remedy of depriving an otherwise legitimate claim is certainly not prescribed in that statute. So could you address that?
So what we're really talking about here then is unfairness, right? It's unfair. It's unfair for a sophisticated business entity that entered into a multi-million-dollar contract.
Counsel, I mean, I'm just going to have to pause you there with this line of, that you're going down with unfairness, because I'm just wondering where the unfairness was when you were cashing the checks. And when you were seeking out the payment from the very company that you're saying was unfair.
Well,
How do we remedy
I would
that?
direct you to A642 of the appendix, where we know that at least those change orders are sent for the purposes of payment. They're being sent. What, is my client now supposed to been working on this job and then I get this? I have to sign these to get paid, but now I'm not supposed to sign those? I'm not.
No, that's not the point. The point is you're getting paid by a company who you're now trying to avoid payment, not because of any business reason, but because you're saying that we should read two statutes in the most harsh way. And so my response to you is that even if we did, they could amend the complaint for a claim for unjust enrichment. We'd be at the same point. And why should we read the statute to allow you to avoid your obligations on a technicality like this? Well, that is the point that I think we're all saying. Okay. Why should we allow that?
And this is not the only case where the harsh results apply. Here, we have the ability to have corporations with limited liability. And all the state of New York asks is that you follow the rules to have that limited liability. And that limited liability requires you to have the proper names, to have the proper assumed names. Look, we have this kind of thing happen all the time, right? What if my company doesn't keep its address with the Department of State?
No, the question, the
please
statute,
let me finish, because every argument I've tried to make, I've been stopped.
Yes, but okay, I'll let you finish your argument, but the point of the statute is to avoid fraud. How is it, are you saying you were defrauded?
No, I'm saying the statute has to.
Clearly, your view of the statute isn't what the statute is intended to do, right?
But it's the view of what this court decided in Roberts versus Ringer Jeans, and if you're going to, then this court should make a pronouncement that that case is wrong.
That case was decided, I can assure you, without the benefit of that panel having understood that 10 days earlier, another panel had reached the unique laundry case. And so there's things like that happen in this
10
court.
years earlier.
I'm sorry?
10 years earlier.
No, not 10 years earlier.
Am I wrong about that?
Both cases were decided in 2018. Unique was decided on October 16th. Oh, I'm sorry, you're right. It was 10 years earlier.
Right, and that's the argument. I know my learned.
You're right, you're right. I'm wrong, I read it wrong. I want to give you an extra minute for the interruptions of your argument. As you said, I don't want to be accused of not giving you the proper amount of time.
The result seems harsh. I don't disagree, okay? But that's the law of the state of New York. That's what happens when a corporation fails to keep their address with the Department of State and they default in a case, right? They may never know about that case and they have a default against them. Will this court vacate that default? No, because they failed to comply with the obligations to be a corporation in the state of New York.
But here's the problem with that Ringer Jeans case, which I think we can distinguish, because there the plaintiff couldn't comply, right? There was no way for her to file an assumed name. But that's not what we're dealing with here, especially when we're given with all of the totality of the circumstances of you cashing the checks. I mean, I don't know if we all have an issue with that, right? That you sought out payment, you got payment. And now when it's time for you to complete your obligations, all of a sudden there's an issue. And that's not what Ringer Jeans is saying. There was a specific issue with that particular plaintiff, the woman, that we can distinguish, and the unique laundry case is more akin to what we're dealing with here.
I respectfully disagree, but, you know, what can we do? Thank you, Your Honors.
And I want you to remember you were given your time. Okay. You may proceed.
Good afternoon, Your Honors. May it please the Court, Aaron Zeriker from Paulson LAPC on behalf of Elite and Premier. I've heard all of your comments. I understand your position. I just want to make a couple very small.
We haven't declared a position. This is the problem. This is a problem with the bar. Our job is to test you, to ask you questions to test the issues. You assume we are in one direction. You should never make assumptions. Our job is to test you. Please don't read beyond that.
Well, no, thank you, because now I feel even more comfortable with what I was going to say. So I appreciate Your Honor clarifying that for me. If you go to the record and you look at the affidavit from the principal of PACE, he says, we used this non-entity, this fictitious entity, to do our mechanical work. They were knowingly going out there and doing business under PACE Mechanical, LLC. Now,
did they do the job?
Did they?
I mean, you say that like this is a terrible thing. And while it did not follow proper corporate form or the way that our State Department would prefer that businesses proceed, did they defraud your clients? Well, did they say they were going to offer services that they were incapable, unqualified, and did not provide?
That, Your Honor, we haven't gotten there because this was a pre-answer motion.
Counsel, you know the answer to that question, whether that is one of your allegations or not. I'm not trying to trick you.
No. My answer is this is a pre-answer motion to dismiss. Never got there, is what my answer was going to be.
And your clients haven't told you whether they, come on.
No. But Your Honor, I wanted to make a distinction, though, about what you were talking about before, about the intent to defraud. Why would a sophisticated company be walking around constantly signing, routinely?
I have a lot of questions about the questionable actions of sophisticated parties.
Okay.
I could fill this building with that.
But PACE Mechanical never existed. The PACE companies existed.
In your motion to dismiss, did you make any allegations that you were defrauded or misled?
No, because it was unnecessary for the purposes.
Well, okay, so because that's you think. Although if you read Unique, you read the First Department cases, you would see that the key issue all around is, are you being defrauded? Is someone trying to fake you out? And then, so again, my question to you is, under our First Department law, did you make any allegations like that?
For the purpose of this motion, Your Honor, I didn't believe we needed to.
Well, okay.
But if I can continue.
But again, so the answer is no.
The answer is no.
Because if you read Unique, for example, and the other two cases, that's a prime issue in all those cases. But you decided you didn't need to.
No, because if you read, Your Honor, Ringer, which came out 10 years after, Ringer makes the distinction that says, if you can't fix it, you don't need to get into the fraud.
Sir, but
it doesn't say that.
Well, Your
Honor, it does not say that.
Can I quote? Can I read it? Can I read it?
I have it right in front of me. You don't need to read it to me. It does not say that.
That's my interpretation of the
That's your interpretation. Okay. That's not what it says.
That was
There's a difference between those two things.
Okay.
Counsel, just do you disagree with your friend that except for the initial purchase order in the caption, which says PACE Mechanical Corp., and the initial purchase order is also making reference to PACE Company, the actual registered entity that's suing you, and all the change orders and everything going after it, that whole paper trail, PACE Company has been clearly set forth therein, except for that initial purchase orders where they mention mechanical, even though you describe PACE Mechanical as being used all over the place, at least for our record purposes. That limited use of that term, that name, the unregistered assumed name, was only used in that context. Otherwise, PACE companies have been used throughout, both in the invoice exchanges and everything else. Correct?
Yeah, but if I can clarify, yes. But if you look at the purchase order, it's not used once. The term PACE Mechanical, it's used repeatedly, and the only time the term
in that one purchase order.
The purchase order.
Yes, that's the one.
Well, no. What I was going to say was, and the only, because Your Honor mentioned.
Weren't there modified versions of this purchase order, and don't they supersede the first one?
No, because the change order, well, not modifications, they were change orders, which happen all the time in a construction contract, and they don't supersede, Because if they superseded, then if the logic is that every single change order supersedes the entirety of an original contract, then we wouldn't have long-form construction contracts. We need to have,
But even the original contracts incorporate by reference other documents that have the correct name of the party. Correct assumed name.
I don't believe mine does, Your Honor. I can go back and double check. That might be the distinction.
I think it does.
Okay.
Okay.
There were distinctions between,
So it wasn't just the assumed name that can't be registered. There are other names that are incorporated by reference into those documents that are the correct name.
the only place it says it is at the very bottom where it says, thank you for doing business with the Pace companies. A percentage of the profits are going to another entity called Pace Cares. That doesn't sound, that to me, if I was reading that and I was on the other side of that contract, it sounds like we have a large group that we call the Pace companies. And by the way, because you're doing with one of our subsidiaries called Mechanical, we're going to give to our affiliated charity some money.
Did they designate, did they say anywhere that Pace Mechanical was a subsidiary?
No.
Oh, okay.
They didn't.
So that was your assumption?
Well, our assumption is a standalone company.
Okay, thank you.
When you sign a contract, you assume that, yes. Thank you, Your Honor.
Thank you. You may proceed.
Yeah, thank you. As Your Honor said, both of the documents are standalone documents. In the entire record, the only reference to the Pace Mechanical Corp is in the purchase order. We're not throwing that name all over the place. It was intended to be a DBA. We're just getting into the business, and they soon stopped using it. And that's why all the other documents in the record, dozens, 15 change orders for one of them, 7 for the other, all use the correct names. The change orders, as you know, when you look at a change order, it changes the amount. So if the original change order was $2.5 million, and you add 500, 400, it says we're changing the number from this to this. It's a modification of it, and on the change orders, it changes the buyer, us, to the correct name. So they signed the change orders, which modify the contract in the correct name. In addition, it's not that they just signed it because they wanted to get paid. They sent their applications for payment. They sent the change orders to the correct entity. They knew exactly who they were dealing with all the time.
Thank you. Okay. School field versus services for underserved. You may proceed.
Thank you, Your Honors. May it please the Court. My name is Scott Taylor from Rosenbaum and Taylor, and we're counsel to the third-party defendant, FJC Security. I know you have a couple appeals in front of you, and we thought it would make the most sense for me to go first. FJC, against whom plaintiff has no claims, had a fully executed, unambiguous contract with services for the underserved. And that contract was solely to provide security services. This action in no way arises out of any security problems, any security deficiencies.
Counsel,
Yes,
please.
Your Honor.
You have a security officer who hears an alarm bell under the contract and the mandate of the Office for Mental Health is required to not just turn off the alarm, but check on the resident. And he claimed that he did just that he physically went upstairs, spoke with the resident, he was fine, came back downstairs. All of that was a lie. So I don't understand how your client can come in here and make this argument.
That requirement is on the facility. My client...
That requirement was on your client's worker.
No, Judge, but with all due respect, it's not. The duties for FJC Security, which is a security company, their guards aren't trained in fire protection, fire prevention.
This is They weren't asking him to act like a fireman. They were asking him to do the de minimis, to check on this is a special housing place. This is not just a regular apartment building, right? We have people with psychiatric conditions who have social workers assigned to them to make sure they're taking their medication. This is not a regular population dwelling. Can we agree on that?
Yes.
Okay, so it is not the basic run-of-the-mill duty here, especially since it is mandated by OHC,
No, but
OHM, to deal with fires in a particular way.
no, those requirements are not on a subcontractor of the facility. Those requirements are on the facility. I don't represent the facility. Had the facility wanted to retain my client or some other entity to provide those services, then they could have contracted for that and paid for that. But the only thing they required of my client is security services.
Well, let me ask you a question, counsel. On page 109 of the record, where it indicates the service level that is to be provided by FJC to SUS, and it lists about 10 things, among some of them using the security equipment, reporting incidents, protecting assets, employees, and guests, monitoring premises. And then we have this testimony from a security guard who goes through a whole story about how he went and checked, he had a conversation, he came back down, he switched the fire panel, he reset it, and then none of that happened. Why can't we look at these two particular things and say, hey, maybe there is some sort of issue here, and that's where we should be going with that?
Well, because the security guard is not in any way authorized, and nobody's suggesting that he can enter into a contract to require his company to provide services that go above and beyond what they've actually contracted for.
So, counsel, if you look at the record, there are people who testified from the building who had held different positions within the context of the facility and the services that were offered. In the record, there's testimony that contradicts what you're saying. You have Norma Gonzalez, the wellness coach at the building, who says that the person on duty had to call the apartment and go upstairs to see if the person was okay in the instance where
but Your Honor, that's
fire alarm came off. You have the former assistant director who said this, to testify that the security guard was supposed to call and go upstairs if the fire alarm went off. You have the security guard, Mr. Joka, who said that when the fire alarm is triggered, it's supposed to be reset, except it was never reset in this case. You have all these people testifying that your client's security guard was a stone-cold, stone-faced liar, and you're saying no liability, no problem.
May I address that?
Please.
I know my time expired.
Go ahead,
Yes.
please.
The wellness coach, nor security guards, nor anyone else can offer parole evidence that's going to affect a clear and unambiguous contract. They may all have thought that was...
Can I interrupt you a second? The contract says FJC security employees are required to enforce SUS policies and procedures, correct? And the fire procedure is an SUS policy and procedure, which the contract says your employees are required to enforce. That's straight up.
No, Your Honor, they're not talking about every procedure in the world that SUS...
I don't know what that... I'm reading exactly from the contract that you're relying on, and it says, the contract that you are relying on says that FJC security employees are required to enforce SUS policies and procedures. Does it not?
Yes, and so therefore...
Okay,
but you're...
there's a fire policy and procedure in place.
Which, by the way, is mandated under Chapter 4 of the New York City Fire Code and was not a mere internal policy because it was governed by the Office of Mental Health.
Judge, again, I point out that those requirements are of the facility, not of a security company. You could impose that same duty then on any contractor who went to work in the building, but.
Well, at
it
least
doesn't impose
anyone
that.
whose contract says that we will enforce those policies. You wrote that contract, you agreed to do that.
Essentially, what the court below did is say that this contract is meaningless. It doesn't matter what it says. What's important is the testimony of the witnesses who said what the security.
No, what the court below said was you agreed to pursue and follow and implement the policies of SUS, and your client failed to do that. But you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Mike Becker for SUS. To begin with, I would like to point out about the contract with FJC. In particular, one of the issues that seems to be arising here is this issue about fire, response to fires. Now,
Gee,
yeah.
We only have a resident who was burned 70% of his body.
Understood. I mean, but my point of this is that under paragraph 6 of this agreement, it refers specifically to.
Of the agreement between SUS and FJC?
Yes, that's correct. It says, it is mutually agreed that the services performed by FJC shall be, and it says refer to Exhibit A. So then you have to go to the proposal that has to do with what they're supposed to do. And there is nothing but example after example of where fire guards and fire safety is all over the place in this agreement, and what extent that they're supposed to be providing services for. When it talks about security personnel levels, there is a specific level for people that are fire guards, trained in CPR, and are certified for that purpose.
So what is your argument? I'm not sure where you're going with this.
So my argument is on this point is pretty clear in the sense that this was not just about security issues. Security is defined in this contract to include fire guards.
Okay.
That's the point that I'm trying to make here.
Let me just ask you, are you the party that asserted the breach of warranty claim? You're not pressing that, are
No.
you? Okay, good.
The breach of warranty, I mean, the contribution, indemnification, both common law and contractual, that all makes sense. I agree, the breach of warranty, that
doesn't fly.
Yeah, that's a non-issue as far as I'm
Okay.
concerned. Okay. So
would you agree, sir, that this relationship between SUS and the plaintiff resident is not a typical landlord-tenant relationship? You would agree?
So the thing
Because
is,
somehow your position is all we had to do was put in an operational smoke alarm, then we're done, one and done.
Well,
but in reality, this was, as pointed out by my learned colleague, this is a unique residence.
clearly, you know, your thoughts about this residence is more than just a typical landlord-tenant relationship. Now, it's assisted living. It's not to the point where we're watching what medications they're taking. That's not our responsibility.
No, but the social worker assists with that.
They don't. The social worker is
The
not.
social worker, according to the record, meets with each client, makes sure that they're in compliance with their regimen of treatment. And you know, at the end of the day, none of that is at issue here, so we don't even have to really discuss that.
Okay.
Right?
Right. So yes, it is our position that we are essentially a landlord. They're essentially our tenants. Our obligation, our duty is only to provide appropriate working.
Wrong. Wrong. Look, if I live in an apartment building, the landlord has to provide me with an operational smoke detector. But I'm in control of that smoke detector. I'm the one who has to keep on making sure that the battery is still active. I have control of that. In this instance, these residents were not in control of their fire alarm smoke detector because it was centrally connected to the main desk, which your security guards, which you hired, controlled, correct? And here, the security guard turned it off when he heard the alarm, did not check, while the man was burning upstairs. So now we have a continuing fire upstairs that's not being detected because your employee
It's not my employee.
From your vendor that you chose, ignored the policies and allowed this man to continue to burn with no detection because now the fire detector in his room was no longer operating because it had been turned off. So I completely disagree with that last statement of yours.
Respectfully.
Am I wrong? Did he have a way of making sure that that fire alarm that fire detector continued to buzz?
So there's testimony in the record from him that it wasn't in his complete control, that he had shut it off in the past, that he had done things to make it shut off in the past. That was, and Your Honor, with all due respect, your position that in any building, they're not hardwired and it's solely the...
I didn't say that. But please don't, no.
Well, you made
Wait.
You gave an example where it was...
Counsel, I'm still talking. And the last time I checked, I'm the JP.
Absolutely.
I'm sorry.
Go ahead.
I'm going to give you time to respond, but I am not going to allow you to usurp my chair.
Absolutely not. I apologize if that's...
I accept your apology, and you have mine if I have have responded in a way that I should not.
Okay.
But you're making an argument that is just categorically, I don't think, true. So you can make your arguments, but please don't put words in my mouth that I did not say.
Okay. All right. Well, I thought, and you can correct me if I'm wrong, please. I thought you made an example of where you had a smoke detector in your apartment and that...
No, I said I don't live in an apartment.
I don't either.
I live in a house. But I'm saying in apartments, landlords have to provide an operational smoke detector. I think we can both agree on that, right?
We totally agree with that. Now,
Okay.
I got to tell you, I have a little bit of personal experience in apartment buildings in New York City. My family has a building that was built in, it's a five apartment place. And those smoke detectors are hardwired into the building, and that was a requirement. It's not a situation that the tenants also don't have control over.
Counsel, if I may, so the distinction here is that the fire alarm, the detector can be turned off. That's the distinction. So if we had a fire alarm that only worked in this building and it went off and nobody did anything about it, right? And didn't investigate and simply turned it off and allowed all of us in here to burn in a fire and not be discovered in a fire that began at 5:30 in the morning, right? Man is discovered at 3:30 in the afternoon with significant burns all over the body. This is an outrage. This is an outrage. And the reason why you're hearing this expressed by the bench is because these were not ordinary tenants. This was a special place for people with special problems who were diagnosed with psychiatric conditions. So there is an enhanced level, there's an enhanced duty of care that's self-evident here. That is why you are hearing all of this.
I think you have more time in rebuttal, right?
Okay, absolutely.
Okay.
Good afternoon, Your Honors. I'm here on behalf of Mark Schoolfield, the plaintiff respondent. And I think it's been hit several times that the facility that Mr. Schoolfield lived in was not simply a building. It was fully controlled by the defendants, including the smoke alarms, the entry into the building, the inspections of his room. And one of the things that I want to point Your Honors to is the defendant's motion for summary judgment against FJC, where they admit that they had a duty under the fire code, under the OMH regulations, but yet they don't make any argument about that in the papers against the plaintiff. The regulations required them to check on the plaintiff. They didn't do that. Instead, they turned off the alarm. They failed to reset it and gave him no chance at getting help.
And just so that it is clear, we know that no one checked on him because there's video surveillance in the hallways, and, correct? There's
correct.
video, and there was no support for the FJC security guard who was on duty when the alarm went off, that he ever went to check on this plaintiff.
That's correct, Your
Am I
Honor.
correct about that?
That's correct, and the defendant's investigator is the one who found that. And I think we can all agree here that Mr. Schofield was severely injured, and the 10 hours that passed in between the time that the fire started and the time that he received treatment caused significant injuries, including sepsis, MRSA, organ failure, and 70% burns over his body. That
In fact, it was the plaintiff who crawled out into the hallway when finally someone was on the floor checking.
Yes, Your Honor, there was a police officer that happened to be on the floor because another resident passed away. And he heard the police radio when he finally woke up after fainting. 6.5 hours, 7 hours later, I think it was even more than that, he heard the police radio and he crawled out to get help from the police officer. And that's the only way he was found. And when they actually saw him go out, the super couldn't believe the amount of burns on him. And that's what I'll leave Your Honors with, unless you have any further questions.
Thank you.
Thank you.
Counsel, you have a minute?
Thank you, Your Honor. If I could just address something you just brought up, and then I want to bring up something I didn't have an opportunity to say first.
Okay.
But with respect to the video, there's been no such video disclosed during this case. It's not a part of the record. There was testimony about a video and what it allegedly showed. But we haven't seen that video. It's not admissible testimony. And as the attorney for FJC, I'd like to see it.
Okay, thank you for that.
And with respect to the duty that the lower court seems to have imposed on FJC, they're saying that, and I know where it comes from, based on the testimony of some of the witnesses, they're saying that if an alarm goes off, the security guard is supposed to go shut the alarm off and then ring upstairs and say, is everything okay? And then the answer, if the answer is yes, still, for some reason, he's supposed to leave his post, which is the entrance to the building, where no one then therefore can go into the building, but to leave his post after he's been told everything's okay, to go upstairs and check on the resident up there. And I know the guy testified and he said, that's exactly what I did. But the point is, it's not even a logical policy. If you ring upstairs and no one responds,
well,
then
you realize we can't override a policy that exists. If there's a policy that doesn't make any sense, that's amongst the parties to work that out.
But where does it exist? It's not written in, it's not in the contract, and that's my whole point.
But the protocol is spelled out under the OHM.
No, but again, the OHM is a duty imposed on the building. It's not.
Which your clients agreed to adhere to.
No, my clients did not specifically, if they were supposed to adhere to that, it should be put in the contract. Again, my position is that their duties are.
Counsel, you're not suggesting that every single possible eventuality has to be included in a contract. If a contract says, you, my vendor, have got to comply with the obligations I have based on OHM responsibilities, and for you to be my vendor, you have to agree.
Insofar as.
Counsel, I'm still talking.
I apologize, Your Honor. I apologize.
Right? So if the contract says you have to abide by the mandate of OHM, then it's in there. They don't have to spell out every single possible eventuality. They don't.
But it would have to be the procedures that are affecting the contract, not every procedure that the building has. They're not taking on all their responsibilities. They're just taking on their responsibilities relative to a security services contract.
Okay.
Thank you, Your Honors.
All right. I'm going to give you 1 minute.
Thank you, Your Honors. I just want to focus back on this agreement. I think it's 99 through 112, I believe, of the record.
Okay.
And I just want to point out a couple of things. In the proposal, well, under paragraph 8, it sets forth, in addition to the list of locations that this contract applies to, it says, in addition to that, look to the proposal. It says in the proposal that there's going to be fire guards under section 2, and then it says, let's get to that one page. It says, we have structured this job we believe that the strong training programs only assure development of security personnel as well as good understanding of FJC and client requirements and expectations. It talks about the level of, that it's tailor-made for SUS through unequaled like experience and customer satisfaction. When you look to the testimony of the FJC guards, they talk about what it's like at other facilities, and it's all the same. They have to monitor the fire safety and the smoke detectors. It's all the same.
Okay, it's in the contract.
Thank you.
Got it, thank you. Gadula 26 versus Lightstone Acquisitions. You have 6 minutes.
Good afternoon, Your Honors. May it please the Court. Alexander Likianis of Rosenberg and Estes for the appellants. To succeed on an anticipatory breach of contract claim, a plaintiff has to establish, number one, the existence of a contract, number two, the repudiation of that contract before the time for performance, and damages. Below, the lower court, in considering our summary judgment motion, purported to address only the first of those three elements and completely ignored the other two. And as to the first element, it profoundly erred. And therefore, we request that the court modify the court below and dismiss the first and second causes of action. With respect to the first element, the existence of a contract, the parties signed a PSA, which provides at paragraph 38 that the parties were obligated to negotiate in good faith for the sellers to acquire up to a 25% interest in the property owner, the entity which would require title to the property. In paragraph 20, had a merger clause which provided that all amendments and supplements to the agreement had to be in writing and executed by both parties. Here, the respondents allege that the appellants offered the terms and conditions pursuant to paragraph 38 in the form of a printed out email which was given pursuant to paragraph 38 of the PSA, and that the parties orally agreed to the terms of that email at the closing.
Counsel, why isn't it just sufficient for there to be a question of fact as to whether or not that constituted an agreement, a binding contract? Defendants are saying that it was not. Plaintiffs have offered evidence of defendants' actions indicating that it could be, and it was a question of fact that'll be left for a later date.
Well, Your Honor, the Article 20 of the contract requires any supplements or amendments to the PSA to be in writing and executed by both parties. And there is no dispute that there is no such writing executed by both parties. And I'd add that the Holy Spirit case, which was affirmed by this court, defines a supplement as something that is added to or issued as a continuation of something else. And the plaintiffs nowhere dispute that definition. And just logically, if you look at—
No, wait. The PSA is, I'm going to sell you this piece of property, right?
That's right.
That's the PSA. This other thing is, and then later on, when this joint venture is, when this hotel is developed, I want a piece of that. Two totally separate agreements, having nothing to do. If it didn't happen, it would not have amended the sale of the property. You're not saying that it amended the sale of the property, are you?
Well, Your Honor, I would disagree with your recitation. Article 20 specifically says supplement or amendment.
Supplements and amendments are to the agreement to sell the property. This is not a supplement to the agreement to sell the property. This is a different deal completely. So I don't know how you could say that for some reason the integration clause would come into play here. I don't see it.
Your Honor, I would respectfully disagree with you. It is
Okay, fair enough,
Article.
Let's go, okay, assume that we don't agree on that. What's next?
Okay, well, I mean, can I just briefly respond that Article 38 is a specific part of that deal, and Article 38 was a negotiated part of that agreement to sell the property, and that was specifically part of it. And there's no dispute that Article 20 applies to Article 38. It's the same contract, Your Honor. It's exactly the same. But even if, okay, let's go to the next thing, okay? So even if there is some dispute as to whether the merger clause applies, the statute of frauds requires any, the sale and transfer.
I'm sorry, sir. I'm sorry for interrupting you, but I had to react. We're not dealing with the sale of real property in the context of the joint venture agreement. They wanted 25% of the Moxie Hotel, the joint venture. That has nothing to do with real property. It's how the real property is eventually being used by some other entity operating it. So when you made the deal to sell to the Marriott, they just want their piece of the pie.
Your Honor, again, I would respectfully disagree with that, because if you look at the terms of the Landau email, which the plaintiffs allege were orally agreed to, it talks about 25% of the property owner, the owner of the property, the fee owner of the property, however that property is used, whether a hotel, whether a...
Let me make sure I understand what you're saying, right? So you're saying that the original deal by plaintiffs to sell to your clients, the defendants, correct?
Correct.
Was later expanded to include the potential for them to JV on the development of the property your clients were buying, correct?
Yes, that is what the plaintiffs are alleging. In paragraph 38...
Right, but what are you alleging? So, because I understand my colleague's question was that the sale from them to your clients was one deal, right? And then in the process, as that deal was unfolding, they were learning what your clients were intending to do in the development of that property, and they then decided, you know, I think I'd like a piece of that deal. And then this discussion about 25% ownership, which would have required them to put up 25% of whatever the outlay by your clients was to develop the property. Am I understanding that correct?
You understand that correctly, but that deal is in the PSA. It is paragraph 38. The paragraph 38 of the PSA, where my clients acquired the property, specifically says that the parties will negotiate in good faith for the plaintiffs to require up to 25%.
Okay.
So wait a second. So if you negotiated and you didn't come up with anything, would you say that you had completed that contract?
If we negotiated and
That's a different thing than saying later on, we finished it, we had a deal. You could complete that first contract and not have a deal. That is not an amendment to that contract. I mean, I don't think it's any clearer than that.
So Your Honor, the parties, in fact, didn't come to an agreement because at the closing, there were allegations of an oral agreement.
And so they're not suing you on the first contract because they're not saying that you didn't complete the first contract. They're saying you didn't complete the second contract.
What we're saying, Your Honor, is that under, number one, under...
I understand what you're saying. I think what's the problem is I'm disagreeing.
Well, let me just ask you this question. I know that you're out of time, but before you sit down.
No, go ahead. This is a complicated...
The email that you're talking about and where it set forth certain terms and it was followed by it was preceded by a presentation on this particular issue. And would you not agree that emails, if they contain certain material facts that are pertinent to a contract and that they can, in fact, be a binding agreement?
As a general proposition, yes, Your Honor, but that's not what happened here. So if you go back, so this contract was signed in the spring of 2014. And again, paragraph 38 of that contract required the parties in paragraph 38 to negotiate this in good faith, which we did throughout the summer, throughout the fall. It's all in the record. Our clients, we tried and we spoke at length. We said at all times, we cannot bring you in as a partner unless and until the capital stack is finalized, okay? So
Meaning the 25%.
no, the capital stack had, so there was a closing on the purchase. There was purchasing financing in November of 2014.
For the original part of the sale.
And well, it was an original part of the sale. The capital stack refers to, it's a complex financing mechanism that related to the ultimate construction, relating to the ultimate use of the property. But to speak to the point that was just made, so all of these documents, all of these emails culminated at the closing. Those discussions occurred at the closing. Nothing was reached. There was nothing in writing at any time. There was nothing complying with the merger clause, nothing complying with the statute of frauds. There's no dispute that there is nothing put in writing at any time. And in fact, after the oral agreement under the original email was allegedly agreed to, my clients were internally discussing a deal on different terms than the oral agreement that was allegedly agreed to. The original email that was supposedly orally agreed to mentioned a 25% interest. My clients were internally discussing a deal after the closing was over of a 10% interest. And the internal emails show that they didn't want to enter into that deal. So there was no deal on the first, because why would they be talking about a 10% deal after a 25% deal was supposedly entered into? It didn't happen, Your Honor. None of this happened. And the reason why we have a merger clause, the reason why we have a statute of frauds, is when we're talking about deals involving real property, and the sole asset of this LLC was real property. So any transfer under, if you look at the Yenham case, if you look at the Strait case, which was only a couple of years ago.
That raises other issues, and there's cases that go the other ways. But I'm more focused. I have one last question for you, and you'll have time on rebuttal. Was there anything in the proposal that your side put forth at the time of closing of the original sale that stated that at the time of closing of the original sale, this had to be agreed upon on that day? Or did it leave it open so that there could be continued negotiations based on what you're saying with the subsequent discussions about now a smaller percentage down to 10%? So in terms of the proposal that they say they accepted, right? Was there anything within that, any language within that that you want to highlight for the court that helps you?
Well, a couple of things, Your Honor. First, not within the proposal, because again, that wasn't a proposal. It was terms for discussion at the closing. What the PSA said was that paragraph 38 that obligated the parties to discuss this partnership did not survive the closing. So therefore, if the parties left the room on November 19th and there was nothing in writing, that didn't survive, number one.
Okay.
Number two, there was an email in the record, and it's referred to in Mr. Milgram's affidavit, I believe at record 2503, where the day before the closing, that provision, that section 38 of the PSA, which both parties agreed governed these discussions, that was forwarded to the plaintiff's principal, and our client requested an additional 2.5 months to have these discussions. The plaintiff denied the extension.
that was an acknowledgement, an implicit, I would say an explicit acknowledgement that the plaintiff recognized that this deal had to happen on the date of the closing on November 19th.
Where can I find that in the record?
It's referred to at it's record 2503, and the email, I believe the email, it was, the actual physical email is not in the record. There was a record reference to it. That record there was a reference to the NICEF, and I can find that for you if you just give me 1 second. I apologize.
All right, why don't you tell me when you come back up on rebuttal?
I'm sorry, it was NICEF 453, Your Honor, where we requested the additional 75 days.
Okay.
And Mr. Milgram's affidavit reflects that that was denied, and Mr. Talasazan's affidavits in response fully acknowledge that that was denied. So everyone recognized that this deal had to go down on November 19th of 2014. It didn't go down. There was nothing in writing, and therefore, as a matter of law, there was no deal.
Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the Court. I'm Jeffrey Ganjami of Court Cetus and Lambros for the plaintiffs, respondents, appellants. Your Honor, to go to the first email or the last email that Mr. Lakayanis just mentioned, it's remarkable that he's relying on that or pointing the Court to it, because that email was an email that was sent to the plaintiffs, Mr. Talasasan, the day before the closing took place, whereby it confirmed a conversation that was had between Mr. Milgram and Mr. Talasasan, where Mr. Milgram told Mr. Talasasan, we are going to close at the $182 million, and we're going to do the partnership agreement. And it's a follow-up email. Mr. Milgram, in his testimony, deposition testimony, says it's a follow-up email, and it's cited in the record. This was to memorialize that the parties had agreed to do the partnership agreement.
But you're not suggesting that that statement is a proper substitute for the agreed-upon requirement that any agreement on this issue had to be in writing, signed by both sides.
No, what I'm saying, Your Honor, is that that email shows that the intent to complete the partnership, to enter into the partnership on the closing date, because there's also testimony in the record whereby Mr. Milgram says that Mr. Talasasan, in order to excuse the defendant's defaults under the PSA, and I don't know if Your Honor, if you want me to go to that. So what happened was the defendants before the closing were trying to require an $8.5 million discount on the purchase price. There was a game of brinksmanship. The plaintiff stood firm and did not agree to do it. So on that closing date, it was a time of essence closing date, the defendants weren't able to fund their purchase price in time. So they defaulted, and there was a panic. And one of the things that was under discussion was, where are the terms of the partnership agreement? And Mr. Milgram has admitted in his testimony that that was discussed, and Mr. Talasasan said that we want to see the partnership agreement terms, and Mr. Milgram said he was going to bring them. There's another conversation that was had in the record, which is memorialized by emails on the morning of the closing.
Counsel, but do any of these discussions obviate or in any way excuse, release, I don't know what other adjective to use, your obligation to get a signed writing as to this other part of the deal?
Well, Your Honor, the email that was created by the defendants, the testimony, it's their admissions, that joint venture terms that is actually defined by Mr. Landau as JV language, that was prepared by the defendants' counsel, Mr. Landau and Mr. Teichman, who was the general counsel.
Okay.
They prepared the agreement, they prepared the terms. It was at the direction of the defendants. They exchanged it, and they brought it to the closing. They told Mr. Talasasan that they were bringing the terms. in order for Mr. Talasasan to close on the
What
following
about
day.
this issue?
So why wasn't that term sheet signed?
Well,
If your
I can
client
tell you.
agreed,
Sorry,
if
sorry.
your client agreed to the terms in that term sheet of their proposal of how they would participate as a JV at 25%, 10%, whatever percent, why was that term sheet not signed? Because you can sign the term sheet and then later reduce all of the fine details of the agreement into a more comprehensive writing. But the only way, based on the requirement that this had to be signed by both sides, could have been effectuated is at the very least to initial something. The term sheet, there's nothing.
Well, Your Honor, the PSA.
Forgive me, Judge Pittsburgh.
Well, no, my question was kind of similar to yours, just focusing on the 10% negotiations that came after. So you asked the question, thank you.
Well, I would, if I may address the first question, Your Honor. The first question you had is that PSA 38 had the parties negotiate in good faith, and it was going to be in good faith on terms and conditions according to the defendants. They negotiated that part of it. So there's nothing in any of the documents that say that a signature was required. There's no disclaimer language.
I thought there was a writing that said it had to be in writing, signed by both parties to be charged, like most contracts.
No, that was the PSA, Your Honor. That the PSA said that if there were any amendments to the contract, they would have to be in writing. But the PSA is different than the agreement that was reached.
So, but the problem is that your adversary doesn't agree that an agreement was reached, and you're saying it was an oral agreement, and that automatically means a trial, right?
Well, Your Honor, I'll tell you why I don't believe that means a trial, and why the defendants don't get the benefit of the doubt here. The pivotal issue in this case, whether the defendants transmitted that at the closing and whether they assented to it.
No, because they're saying, here's our broad outline. We're required. You're saying something different. You're saying, no, this is A, B, C, D, E, F, and G, and we agreed to them. They're saying, at that meeting, we presented to you as a broad outline of what we are going to negotiate, and you said, okay, let's negotiate. We don't know who is right and who's wrong. There are two separate sides. Go to trial and let the fact finder figure out who the right which the right version is. Right?
Well, I would just say, Your Honor, that in the first appeal, the defendants took a completely different position, that the email, Mr. Landau's email, was essentially stolen at the closing table by either my client or my partner, my law partner, and that somehow this was outlandish, that we were even bringing this, that we fabricated this whole case. What happens is, as the case goes on, they completely changed and admitted that they created it, they delivered it, and that it was, and it's not been denied that was accepted, and the fact
No, it is being denied. That's the whole point. They're saying, with this, we created this sort of, this is what we want to negotiate, and you're taking a different view of it, and they're saying, in any event, we didn't all agree on it, and because it's all oral, because your client didn't sign anything, you have to have a trial.
Well, all the evidence, Your Honor, and I respectfully submit that all the evidence shows that these parties they intended to negotiate for a partnership joint venture. It's in the paragraph 38. It says partnership agreement. It's in there, and that there was no reason for the JV terms to be delivered on that day to my client on the closing unless the parties were prepared to enter into the agreement.
Sir, I know it wasn't raised earlier, but I might as well ask you. The issue of the eviction.
Yes.
My understanding is that on Supplemental Record 1000, there was a clear representation by their representative that you folks can stay there for 6 months after the closing, correct?
Yes.
And what happened was, like shortly afterward, they immediately started illegally locking you out.
Yes.
So that's real.
Yeah, the evidence is much more powerful than that, Your Honor, I respectfully submit, because that email was sort of the icing on the last piece of it, the telltale heart, because all the evidence shows that this post-closing occupancy agreement was discussed before the PSA was signed. It was very essential because The plaintiffs had their headquarters there for over a decade. They had a prayer center there. This was not something, and there was no reason for them really to get out because there were demolition clauses and tenants were getting out. They were being vacated as the project was going on. So there was no reason for them to get out. Anyway, in any event, Your Honor, there was also emails that were sent to a team of lawyers for the defendants before the PSA was signed. There were emails with the post-closing occupancy agreement sent on the morning of the closing. And then, remarkably, in discovery, electronic discovery, the tenant stacking charts were produced, and the metadata on those show very clearly that they were created during the contract period, and they were modified before the eviction took place, and they showed that the plaintiffs were allowed to stay for 6 months. So the evidence is overwhelming that this was just clearly a message sent to our clients that, hey, we have the property now, and we are not doing business with you. We're never going to make you our partner. We're never going to make you our joint venture, and you're out of luck.
Thank you.
Thank you.
You have 2 minutes, and as much time as I gave you on the front end, I'm holding you.
Oh, okay, I got it. Understood, Your Honor. One thing I want to raise is that, again, there are 3 elements to an anticipatory breach cause of action. We talked about the first element. You still have the issue of whether there was an anticipatory repudiation and whether there were damages. Mr. Gangemi just referred to a message that was supposedly sent. That's not what the cases say. The cases say that any alleged anticipatory repudiation has to be positive and unequivocal, and other courts refer to it with similar language. Here, we had an alleged lockout, and I can.
It wasn't alleged.
Right.
They were out of their property for a day, at least.
It was a few hours, but regardless of what it is, there was a lockout there was a dispute over whether they were permitted to stay. And then there was a dispute over the amount paid for the property at the closing. Completely separate and apart. Mr. Gangemi has alleged it's completely separate and apart was this other agreement about the 25% interest in the entity. Taking acts relating to those first 2 items had nothing to do with that other entity. It was completely separate. So even if there was a separate agreement, or even if the merger clause didn't apply, he's got to go 3 for 3. He can't just go 1 for 3 and get to trial. He's got to establish all of them. And it's clear, if you look at the actual facts and logically look at what's being alleged, the items allegedly manifesting the breach have absolutely nothing to do. They are not positive and unequivocal. And our clients even state in his affidavit that had there actually been an agreement, it would have been complied with. But because the anticipatory breach, because the lawsuit was commenced in December of 2014, in advance of the alleged time that the performance...
Are you saying that the agreement to allow the plaintiffs to stay on the property was contingent upon there being a JV?
No, no, I'm saying the exact opposite, Your Honor. What I'm saying is...
So then I don't understand what one has to do with the other.
Frankly, I don't either, Your Honor, and that's the point here. Because the second element of anticipatory breach is that it has to be a repudiation. It has to be positive and unequivocal. And what Mr. Gangemi is alleging is a positive and unequivocal breach of this alleged JV agreement is that we served a default letter relating to the contract and that we locked them out. But those 2 items have nothing at all to do with this allegedly separate agreement.
Okay.
But counsel, let me just ask you, you're not disputing that you illegally locked them out. You did, right?
Well, yes, I am disputing that, Your Honor.
In what way?
Because, well, again, this is all detailed in our affidavits. When the PSA was signed in March 31st of 2014, there was an Exhibit J next to it, which was a rent roll. The copies of the rent roll...
let's assume that they had to get out the next day and they didn't. You still can't change the lock. That's still illegal, right? You have to go to court. Can't lock them out. You change the locks, right?
This is not a residential situation.
Even in a commercial situation, you cannot just go change the lock.
With respect, Justice Scarpullo, I disagree. If you don't breach the peace and there's no one there, and there's no right to be there, it's not a residential landlord-tenant situation. The
All right.
cases are very clear on this.
All right, you're out of time, and I have to say that was not your best argument. Come on up.
To just respond to counsel on the argument of the anticipatory breach and the unequivocal overt statement by them that they were not going to honor the agreement, that they would honor the agreement. There's nothing in the record that indicates that they would ever have honored the agreement. They've disaffirmed it from day one. The letter that they sent, you have to also put it in context, Your Honors, of what happened. So this closing takes place. My client allows them to close. My client could have taken $9 million deposit, kept the appreciated property, and moved on. Based on all these representations and everything that was going on, he gives them another day to close. Time is of the essence. They go, they have this meeting. Mr. Milgram goes with Mr. Landau. They bring the Landau email. They discuss it. Our client accepts it. They shake hands. Everybody's fine. Hours go by. Everybody leaves upbeat, thinking that there's a partnership and there's a closing. Everybody's happy. Hours later, the same day, our client gets a letter, a default notice from Mr. Teichman, not Mr. Milgram, who's had a very good relationship with our client, who's trying to make a deal. Mr. Teichman, the general counsel, sends a letter saying that my clients are in default, but more importantly, what he says is, and carefully crafted, is that the defendants were forced to effect the closing, which means that everything that happened at the closing, including the partnership agreement and the joint venture agreement, was tainted, was negated. So for them to take the position somehow that that letter should be irrelevant and you should read it so strictly because a lawyer drafted it to try to avoid any obligations, I would respectfully submit should be rejected. And then also the issue, Your Honor, with respect to this lockout, I would say that joint venturers and partners, there's a duty between them to take care of one another, treat each other with the utmost decency.
But you're not dependent on that. I mean,
I'm not dependent
you're depending on that email that said the deal is 6 months. That's what we got. That's chargeable. That's an email from them, chargeable to them. And then right after, they locked you out, right?
Right.
That's what you're dependent on.
Right. But what I'm saying, Your Honor, though, is that it's clear that if you are going to you're going to bring somebody down and forcefully force people out of their offices and the prayer center, it's obviously you're telling them very clearly, we're never going to be a partner. I mean, that they can't be clearer than that. So I will leave it at that, Your Honor. Again, I would just also mention that again, I would hope that it should not be irrelevant that the defendants came here and came to the Supreme Court with a completely different factual position that was quite frankly scandalous on a lot of levels, and that they just decided to change it mid-case because they thought it suited them, and now they're coming here with a completely different argument. Thank you.
Thank you. Okay. Andes Petroleum versus Occidental Petroleum. You may proceed.
Good afternoon, Your Honors. May it please the Court. It is nice to be here. Zachary Rosenbaum for the Appellant Occidental Petroleum Corporation, which I may refer to in short form as OPC. I might also refer to the plaintiff respondent in short form as Andes. The alleged fraudulent conveyance here occurred in 2016. Andes brought this suit over 5 years after the claim accrued in Ecuador, at a time when Andes could not bring this action in Ecuador, both because A, the action would be time barred there, and additionally and separately because B, constructive fraudulent conveyance claims are non-cognizable in Ecuador. Thus, under the borrowing statute, first and foremost, the trial court erred in not dismissing this case by applying Ecuador's 4-year statute of limitations for fraud. And in addition, the trial court erred by applying New York substantive law under choice of law principles when it is established law in this department in particular that where non-residents bring conduct regulating tort claims in New York, that the court looks to the place of injury to determine what substantive law applies.
And to be clear, I'm sorry, and to be clear, the only connection to New York on this case is that the arbitration occurred here and that the settlement monies were deposited in a New York bank. Am I correct about that?
I would submit that the only connection that has any tie to the alleged fraudulent conveyance is that the settlement monies were paid into a New York bank account. But yes, there was a subsequent, which I think is important, a subsequent arbitration a year and a half later that was seated in New York that relates to ultimately
Right, those are the only two connections to New York.
the only tangible
Right.
connections. The plaintiffs cite heavily to the existence of a judgment that came many years later, but I'd submit, again, I'm now on the choice of substantive law issue, not the barring statute issue, but this court in 2020, in the matter of Wimbledon, which we cite multiple times in all of our papers, looked at almost an identical set of facts.
So,
and this was on the choice of law.
I want to ask you a more simple question.
Sure.
Understanding that the 10-year statute of limitations was applied here, using the acción colusoria standard, as opposed to the 4-year statute of limitation, which is applicable when there's a delito civil. Do we really have, sorry, I got this stuck on my earring. I really did. Do we have enough information in the record to understand what the difference is between these two definitions and these two statutes under Ecuadorian law? Because I went back and forth in it, and thank you very much. And I had difficulty.
So it's a very good question, Your Honor, and I'll try to answer it in layers. I think, and that brings us to the barring statute application. The trial court, as a matter of prima facie standard, in other words, the defendant has to make a prima facie showing that the case is time barred. And the trial court imposed a rule that we submit does not exist in this department or in the state of New York, which is that the defendant has to point to a directly corresponding cause of action in the place of accrual. And here, as there really is little dispute, that there is no implied fraudulent intent in Ecuador, and therefore, at least as to the constructive fraud claims, there is no directly corresponding cause of action, but there is a cause of action for fraud, and it's delito civil. And the Ecuadorian law states, and I'll quote it, and it comes from Professor Villalba's affirmation, the action prescribed in this title relating to damages or fraud will lapse in 4 years from the perpetration of the wrongful act. Now, Your Honor's question about acción colusoria, the trial court actually rejected, appropriately so, that cause of action because it is specific to, and I'm not going to pronounce it nearly as well as Your Honor, but inmuebles, that's the word used in the statute. The word used in the statute means real property only. It does not mean cash. It does not mean rights to a settlement proceeds. And therefore, the trial court here rejected acción colusoria, which to me is confounding because we came to the trial court, presented the statute of limitations for fraud, met our prima facie burden that the case is time barred. There was the finding of the trial court found no appropriate rebuttal to that because it found that the cause of action that Andy's put forward was facially inapplicable. But then went to this default statute of limitations, which neither side argued for, independent of a cause of action, of a right in Ecuador, and said somehow, frankly, by legislating in Ecuador, I think, although that's not the words that the court used, it surmised that that 10 years could apply. But we submit that doesn't make sense, particularly based on the aims of the borrowing statute. The borrowing statute is designed to, A, prevent forum shopping, and B, provide predictability and certainty of result to litigants. So if the premise is that the claim is not available, actually a more permissive claim in this case, a claim of fraud, and to be clear, this is fraud in New York, it's just fraud where the law implies intent, but where a claim for fraud is unavailable in your home jurisdiction because we don't imply intent, but we do provide for a 4-year statute of limitations for traditional fraud, somehow I'm going to look to a 10-year statute of limitations, even though I've also rejected the cause of action that the plaintiff put forward.
Okay, you finish your thought and then you'll have time on rebuttal.
One note, because I think it's important. On the choice of law issue.
Okay, that's not one note, that's a new argument. Okay, I'm going to give you 30 seconds to
30 seconds. I just want to refer to the court to a case that we did not cite, but it speaks specifically to the choice of law issue, which is SFR Holdings versus Rice, First Department, 2015, 132 AD 3D 424. I provided it to counsel yesterday evening, but that case, specific to a fraudulent conveyance claim, says that for non-residents, where the plaintiff and defendant are not residents of New York, the claim accrues in the place of injury. And here that is Ecuador. Thank you.
Thank you. Your mask.
Your mask is here.
Sorry.
You may proceed.
May it please the court, I'm Stephen Jacobs from Herbert Smith Freehills on behalf of Respondent Andes. I'd like to start by clarifying a couple points that your honors raised when Mr. Rosenbaum was speaking. First of all, just the lower court did not decide that Acción Colusoria was more analogous than delito civil. The lower court actually said that the default statute of limitations in Ecuador should apply because neither is analogous in the trial court's view. Allow me to explain. The trial court followed this court's guidance from Merritt v. Blumenthal to a T in determining that Andes' claims are timely. In that case, this court considered the application of the borrowing statute to a Judiciary Law 487 claim, which, as your honors know, is a New York-specific statutory action for attorney deceit. The claims at issue in Merritt accrued in Pennsylvania, which the court explained had no statute analogous to New York Judiciary Law 487. Thus, the court in Merritt applied Pennsylvania's 2-year default limitations period, which applies to, quote, any other action or proceeding which is founded on negligent, intentional, or otherwise tortious conduct, including deceit or fraud. As set forth in our brief, Pennsylvania Supreme Court has referred to this statute as the default or catch-all 2-year limitations period. And that's precisely what Justice Cohen did here with respect to the borrowing statute. After a painstaking analysis of Ecuadorian law, he determined there was no analog, so he applied.
Let me just ask you, that's not what your expert said, right?
That's correct.
So he didn't go by your expert, he just went a different direction. So that wasn't your argument before him at all. You came out with a 10-year statute, but it wasn't based on this. It was a different analysis that your expert did.
Yes and no, Your Honor.
No, yes and yes, right? Your expert never said immediately apply the default statute, correct?
Correct. We contend that
I want to make sure the counsel was correct. Neither side argued for what Judge Cohen did.
that's correct, Your Honor, to an extent. Before the lower court, we contended that axion collusoria, and we would still contend, is very closely analogous to Andy's DCL claims. And I can address counsel's argument that axion collusoria applies to inmuebles, which counsel contends is real property, and therefore only applies to
Right, but the problem here is that the judge below didn't look at your two experts. He decided something else. That's the problem. And we don't, and there's no thing in the record that says that this default statute is better than either what your expert said or the plaintiff's expert said, right?
Your Honor, I don't have, I believe it's CPLR 4051 in front of me regarding the court's discretion to take judicial notice of foreign law. But if I'm not mistaken, I believe the court has broad discretion to take judicial notice, including not only expert affidavits provided by the party, but also the court's own research or any other source that the court wishes. And that's precisely what Justice Cohen did here. He looked at the statutes along with the First Department law from Merit, which is pretty clear that an analog is not needed, and decided that since there is no direct analog, if the claim could be
But again, your claim was that there was a closer one, not that the default statute applied, but there was one that was analogous, and it was the other, there are two, the other statute. You never argued that the default statute applied, neither did the plaintiff. The plaintiff argued that the 4-year statute one applied. You argued that the other 10-year statute one applied. And one of them has, neither one of you argue that neither one of them are analogous enough to do the analysis in our First Department case. That's the issue here, how the judge came up with something, a third thing.
Your Honor, to the extent delito civil does not apply, the action cannot be dismissed on this record. And again, I believe Justice Cohen had the discretion to take judicial notice of Ecuadorian law in the manner that he did. I would like to also briefly address the point.
The term in and of itself is like probably the most generic. Any civil action is what that means. Delicto civil is like any civil charge. I mean,
Your Honor?
Any civil charge.
Respectfully, I would disagree. As Justice Cohen analyzed delito civil, and as defendant's expert admits, a delito civil requires fraudulent intent. That is an extremely big difference between delito civil and Andy's claims pursuant to DCL 273 to 275 that only require a lack of consideration and no fraudulent intent, a transfer that renders a defendant insolvent, for example, without fair consideration. That's it, no intent element. In addition, delito civil has different remedies than Andy's fraudulent conveyance claims. So it has different elements and different remedies. It's not remotely analogous. I would also like to briefly touch on the substantive choice of law point.
I will give you, as I did him, 30 seconds.
Thank you, Your Honor. I believe you asked my colleague if the only, I don't want to put words in your mouth, but if the only New York contact was the New York bank account that the transfer went into.
No, I said that the only connections were the arbitration and the fact that the settlement monies were deposited in a New York bank.
Yes, Your Honor. There are significantly more New York contacts here.
But you can't possibly argue that the New York connection to this case is greater than Ecuador, where this happened, where Ecuador accepted the assistance of these companies to build out their gas lines and then basically said, okay, you could go now that you've given us almost $1 billion of your money to develop our infrastructure.
Your Honor, with respect to the fraudulent conveyance specifically, the only connection to Ecuador is that they were the transferor, and that they are where Andy's is based. But the domicile of the parties for conduct regulating torts is when the parties are from different domiciles is not the relevant factor to look to. That's my adversary's primary mistake on this front. He relies on, for example, Wimbledon, the Wimbledon case, where both petitioner and respondent shared a domicile. As Justice Cohen recognized, New York law is clear that where parties do not share a common domicile, such as Andes and OPC, the conflicting rules involved in the appropriate standards of conduct, the law of the place of the tort will have the predominant, if not exclusive, concern. And the tort here has every connection to New York. Not only was it transferred to a New York bank account, Andy's entitlement to the funds to begin with comes from a letter agreement from 2006 in which the parties chose to be governed by New York law. The settlement agreement between Ecuador and OPC, my adversary, was governed by New York law. That's page 903 of the record. The arbitration award was in New York, and the judgment that they're evading was a New York judgment. And as the cases we cite in our brief say, when a judgment debtor is evading the payment of a New York judgment, New York law is particularly important to be applied.
Thank you.
Thank you, Your Honor. Starting with Merritt versus Blumenthal, respectfully, I think counsel and frankly, the trial court got it exactly backwards. If you read Justice Freed's underlying decision, it's abundantly clear what the court was doing. The court was not going to a default statute of limitations in Pennsylvania. It looked to what it considered the most analogous to a Judiciary Law 487 claim, and it identified them. It said tort-based legal malpractice, common law fraud, and statutory rights. And by the way, those are in different subsections of the same part of Pennsylvania law 55.
So then if we agree with you on that, then it's a battle of your expert and their expert. And if the trial court believes their expert's view on it, it's a 10-year statute. And if it's, which doesn't matter whether it's the default or the 10-year. And if the trial court believes your expert, it's a 4-year statute, right?
I don't disagree with Your Honor. I think that issue can and should be remanded, but with instruction, because I think the way that the trial court applied the barring statute requires some type of direct analog, which the trial court also concluded doesn't exist. So we're in a place that is outside the law of this department. But Merritt, we submit, fully supports what we asked this court to do, which is either reverse or at a minimum remand. On the choice of law issue, I'll just read from this SFR case, which says, the claims are governed by the law of Cayman Islands and Delaware, as that is where the injury occurred. And it starts by saying they were claims for actual and constructive fraudulent conveyance. That's what happened ultimately in Wimbledon. I don't think it uses the exact same language. But if you look at the underlying in Wimbledon, the connections to New York were at least as significant. I would submit more significant. And there was a New York judgment. And the court, this court, directed the application of Cayman law. And I know my time is up, but one final point. If the court is even going to consider a judgment that was entered in 2021 for a transfer that happened in 2016, then from a government interest standpoint, it should look to the fact that this legislature in New York has passed the UVTA, which would look to 4 years.
I mean, that's a trial issue, though. That's
I just submit that the timing of the judgment is entirely irrelevant because it was 5, 6 years later. Thank you, Your Honor.
Thank you. And last but certainly not least, People v. Mitchell Hernandez. Yes, you may proceed.
Good afternoon.
Good afternoon.
May it please the court. My name is Alexandra Conlon, and I represent Mitchell Hernandez, the appellant. Because both sides have clearly set out their positions on the two issues relating to the conviction itself, the Sandoval issue and the in-court ID, I'd like to use my time to discuss the sentencing issue, which I think raises an important question of statutory interpretation, unless your honors have any questions.
Proceed.
Great. So Mr. Hernandez was wrongly sentenced as a persistent violent felony offender because the trial court misapplied two subsections of Penal Law 70.04, subsections 4 and 5. To be clear, Mr. Hernandez had 10 years of street time since imposition of sentence on the predicate felony that was at issue. He should not have been sentenced as a mandatory for that reason. Now, on the unique facts of Mr. Hernandez's case, the outcome for him turns on whether or not this court deducts from the time that he's at liberty after imposition of sentence on that predicate felony, time that he was incarcerated prior to sentence on that first predicate felony. That's the only way for him to be a mandatory. There's this 9-month period of pre-imposition of sentence detention that affects the outcome for Mr. Hernandez. I cited in my brief, and the people cited in theirs, a case, People v. Meckwood, from the Court of Appeals, but I didn't focus on it there, and I think it actually makes this issue a lot simpler. In that case, on page 3 of that case, the Court of Appeals, in passing, states, Penal Law 70.04, subsections 4 and 5, prohibits enhanced sentencing where more than 10 years have passed between sentencing for the prior felony and commission of the present felony, and here's the important part, excluding all periods of incarceration during such time period. So what we're arguing is very simple. Section 4 tells us when the clock starts. The clock starts at imposition of sentence on the predicate felony.
Doesn't Section 4 also say, except as provided in Section 5? And then when you go to Section 5, it talks about any time between the commission of the previous felony and the present felony?
Judge Pitt, I think that's, of course, the exact problem that the trial court identified, and I submit that it's impossible to give a literal reading to that language in subsection 4 about imposition of sentence as the relevant time period, and that language you just pointed to in subsection 5, which takes you back to commission of the previous felony. Essentially, subsection 4 is supposed to sort of create the look-back period. That's the setup of it, right? Like, if you look at the structure of the statute, and that's consistent with the purpose of it, which is that we want to punish more harshly people who haven't managed to have 10 years of street time since that previous conviction. And section 5 tells us how we determine when to stop the clock, and it's for any reason you're incarcerated, whether it's pretrial or not. But obviously, what the trial court was hung up on and admitted candidly on the record, and what commentators have noted when they've talked about how to apply this statute, is the difficulty of the language between the time of commission of the previous felony in subsection 5, and of course what you, oh, sorry,
may
go
I just
ahead.
ask you, isn't there like 25 years of cases that say from our department, the third department, the second department that apply this in the way that the trial court did?
So a couple of responses to that. The first,
I mean, we just did it in 2018, right? So
are you talking about People v. Cortez or something else? In any case,
anonymous, right? People
v. Anonymous.
And then we started with People v. Cortez in 1996, which, right?
Yes. So
96, 2002, like 25 years or more of this.
So as far as
all that 25 years worth of law is wrong?
So I think that the 25 years worth of law that you're talking about doesn't address the unique question that's presented here. Like, absolutely, People v. Anonymous, People v. Cortez, the other First Department case on this, and the two others cited by the people are appellate division cases talking about these statutes. And they all say, of course, you can count against the defendant, time that the defendant's incarcerated. None of them seem to speak to directly a period of time where the person was incarcerated before imposition of sentence on that first predicate felony, where you're doing this sort of look back, like answering the question, when does the window begin?
Well, let me ask you this question before you get to that point, because the time that someone serves pre-sentence counts in terms of good time, time served. It goes towards their sentence. They're not starting from the date of sentence and then serving, what, a 3 to 7 or whatever the case may be, right? Why wouldn't, so it's allowed to be considered there, why wouldn't it be allowed or be proper in this particular instance as well?
So a couple of reactions to that, and I think that that is obviously the reasoning set out in People v. Kennedy, which this court upheld in People v. Cortez, just the question of credit on the back end for time that you're in pretrial. So I think the first is that this statute, Penal Law 70.04, isn't differentiating between people who are in on bail, remanded, out on bail on the back end to make sure they get the same results. And in fact, the appellate division cases that we were just discussing, some of them reach results that seem undesirable on the basis of the fact that this statute doesn't include any sort of carve-outs for time that somebody shouldn't have served, like where an error has been made or they had an unconstitutional conviction. I think second, as a factual matter, as Your Honor likely, of course, knows, it's not always the case that a person who is in on bail pretrial gets that credit on the back end. If somebody is in on a parole violation serving a sentence, but also in on another case, they don't necessarily automatically get credit for that pretrial time. And of course, sometimes you can do
They do if their lawyer does their job right.
some fancy footwork to get the nunc-pro-tunc to go back.
It's you make the application before the judge. That's lawyering.
Well, I agree and wish that always happened. My point is simply that it's not as though that is sort of categorically true. There are steps one has to take. I think the sort of more important reaction to this is that the government's reading of the statute creates an entirely separate, undesirable result. So the result you're talking about is essentially the idea that someone who's out on bail is getting sort of harmed by this interpretation in the way that someone who is in on bail gets credit on the back end. I would submit that the government's reading of the statute, or what the trial court did, creates a different undesirable result, which is that a person who fights their case, so the person stepped in on bail, fights their case for, say, some period of time, and then later in the case gets convicted, sentence imposed. That person is at a disadvantage when it comes to determining their predicate felony status in the future, as opposed to somebody who pled quickly and had sentence imposed quickly, if you calculate it the way the people are calculating it. So I think the point here is that 70.04 doesn't exist to try to avoid.
I'm trying to understand then, what is the workable rule that you think the court needs to employ that would be supported by the language in the statute they are following?
So, Your Honor, I think that's why I wanted to start with People v. Meckwood, because I think the Court of Appeals articulation in passing of this statute, the way they describe it, is the exact right solution and doesn't require anyone to ignore any part of the statute. Section 5 stops the clock that gets started by Section 4. So anytime someone's incarcerated after a sentence has been imposed on their prior predicate conviction counts against them for any reason. But we don't sort of do time travel back in time and hold against someone who has 10 years at liberty time that they were incarcerated before they ever had a felony conviction, which is exactly what happened to Mr. Hernandez, who would not have been sentenced as a mandatory otherwise.
Thank you. You may proceed.
May it please the court. Good afternoon, Your Honors. Christian Rose on behalf of the people. I'll just turn straight to the predicate sentencing. The court correctly ruled that the defendant was a persistent violent felony offender based on the plain language of the statute. I don't think we need to go any further than the plain language of the statute here. Subparagraph 4 sets the baseline for the period of time from the sentence that the defendant must remain free from the sentence of the first felony, but it subjects itself to the calculation mechanism in subparagraph 5, which says that you need to extend the period by any time that the defendant has been incarcerated between the commission of the felony and the commission.
What about counsel's point that that interpretation kind of has the effect of being adverse for people who step in on bail, as opposed to people who plead quickly and are sentenced quickly, as opposed to people who fight their case and wait long periods of time to get a trial?
Well, that was addressed in Kennedy, as you know, and in this court, in discussing Kennedy, said that consideration would not be an issue when the time was credited. And there was no allegation that the time was not credited in this case, and for that 1990 felony. And so without that, I just don't think that we have those issues. I also want to note that I believe that the statutory interpretation arguments are unpreserved. Kennedy deals with constitutional arguments, and in the application for, the basis of this objection was People v. Kennedy, which is just a constitutional case. It's not the statutory interpretation about the structure of the 7004 or how the definitions of the word exclude prevent this from operating. I think that in order to have a plain language argument also based on 7004, you have to eliminate the word commission from subparagraph 5. If there are no other questions about this, and if there are no other questions about the trial issues, we just ask that this court affirm defendant's conviction.
Okay. Counsel, you have time on rebuttal.
So to be clear, People v. Kennedy raised a constitutional claim about the ability to pay bail or not to pay bail, which is not the point that I am making here. The point I'm making here is that the government's interpretation of this statute puts people who have a longer time between commission and imposition of sentence in a worse position, which is people who are fighting their cases or for whatever reason have court
Let's
delay
say
or
I
anything
agree
else.
with you. Is this something that this court can do something about? It seems to me that the argument is one that is better put forth to the legislature to change this statute so that precisely what you are discussing does not happen. You understand? I mean, I just don't understand. I absolutely understand your argument, and I get it, right? My concern now is, all right, so I get her argument, and she raises legitimate arguments. What do I do with the statute I have before me that I have to follow the letter of the law on?
I hear that concern and, of course, have a bone to pick with the legislature about it and understand that's not this court's role. But
welcome
this
to the
court,
club.
but this court has to help trial courts understand how to reconcile these two provisions, subsection 4 and subsection 5. Our judge and the judge in this case was very clear that there appeared to be a tension. They didn't know how to resolve it. I think, first, as an aside, when there is a tension that a trial court can't resolve, they should go in the favor of the defendant, which is obviously not what happened here, and so would point to Penal Law 5, Penal Law 5 and the rule of lenity to say this was wrongly decided, but sort of more broadly speaking, we need a workable interpretation of subsection 4 and subsection 5 for trial courts until and unless the legislature acts. And we submit that the way that the Court of Appeals describes it in Meckwood is the exact right way, and it still gives meaning to both subsections. They're still both doing work, because if you go the people's way, imposition of sentence isn't doing any work at all in subsection 4. Thank you.
Thank you.